Okay. First question. What do you believe is the most important responsibility of the prosecutor?
Well, the most important responsibility is to, of course, prosecute criminals and do so in a way that deters people from committing similar crimes in the future, and to make sure that if there's a victim of a crime, that the victim gets the justice that they want and, quite honestly, that they deserve.
Very good. Okay, what would success look like for the prosecutor's office under your leadership, including the effectiveness of the attorneys, the office staff, and support team? And how would the public know that it's working?
So the way it needs to work and what needs to happen is we need to have a situation where obviously if there's victimless crime, there's no real victim to complain about the job that the prosecutor did. But at the end of the day, if the victim's complaining that they don't feel that the prosecutor did everything they could to vindicate their rights and basically deliver justice, then somebody's failed. And as the lead of the office, it would fall on me if they fail to do so. And it would be my job to make sure that all of the staff, the deputies, and everybody worked together to make sure that crimes are prosecuted, tough sentences are given, and that victims don't really have any complaints. And to be honest, they complain about some of the plea agreements. We can definitely fix that right off the bat to where if they don't like a plea agreement, we obviously don't go through with it. If we go to trial, we can win, we can lose. If we have open sentences, then the judges can make their rulings. But for the most part, the judges are pretty stiff in this county when it comes to crimes where there are victims. So getting into the judge's hands doesn't concern me at all. But like I said, winning cases, delivering a satisfied victim with the outcome is really what I'm after here. And I think if you've been tracking my campaign at all, one of the big things that I have a problem with is the light sentences that are given in plea agreements to people who victimize children. And that's going to be my priority, my focus.
Okay, very good. And that kind of touches on the next question that I have, because voters want to know that true child predators are prosecuted aggressively while ensuring innocent people are not destroyed by false allegations.
Yes.
So how would you balance victim protection, evidence standards, plea negotiations, and due process?
So the big thing that I have a problem with is there's not a lot of oversight and communication with the police and the prosecutor's office. And I've heard this complaint from police and prosecutors, or I'm sorry, police and people who have been in the system for these things, is that the detective will frame his report in a way that creates probable cause. And the prosecutor's office just signs off on those. And I have had several cases. They've now been expunged, so I really can't go into detail, but it was basically if the prosecutor would have reviewed the evidence, would have pushed the detective to get into more detail, then the case would have been either more solid or never would have been filed in the first place. And something that a friend of mine who used to be a prosecutor in an adjacent county told me was that as a prosecutor, you have to understand your case is only as good as it is when you file it on the first day, because after that, the defense attorneys come in and they start chipping away at that case, chip, and the case gets worse. And so you have to make sure when you go in and you file that case is tight and ready to go and will withstand the challenges that adequate and, quite honestly, some very good defense attorneys will take a shot at. There was an old deputy prosecutor here. He's since passed away, but he would have his lists, and he would say to a detective or a police officer, okay, you want me to charge this crime? Fine. This is the list of evidence that I need. This is the list of things that I need you to create a record of, so that I know whether this evidence exists or not. And if it does, let me know. And if it doesn't, let me know. And if it's something that we can get, let me know. But he does, but you can't just hope that a defense attorney doesn't chip away at the case. You have to present your strongest case day one when you file it. And that's the big issue that I see, is there's just not that communication. And a lot of it flows from a lack of trial experience that's in that office right now. If you don't try cases, you don't know how to try a case. If you don't know what a defense attorney will do on the other side because you've never been one, or you've never prosecuted a case at trial, you're not going to know what that list should be. You're not going to know how they're going to attack that case. Now, I have been a defense attorney for quite some time, and I know all of the processes that a defense attorney goes through. I know how they attack evidence, and I can be prepared day one, if we need to have a trial, to go in there and know what the defense attorney is going to try. And I tell everybody, Michael Jordan didn't come out of his mama knowing how to shoot a ball or dribble a ball. He had to learn, he had to try, he had to succeed at some things, fail at the others to be great. And that's the thing, is if you haven't tried a case, you don't know what it takes. I remember the first time I tried a case, I had no idea what was around the next corner. And it was only by trying some cases, winning some, being unsuccessful in some, that I learned how to do that. And if you haven't done it, which there's a couple of people in that office who have not done that, then they're not going to be successful trying cases, and they're going to lose them. And and the other problem you have out in the real world is criminals run together and they talk to each other about what happens. And if they think a prosecutor's office is soft, then they're going to know, and they're going to force their attorney to ask for something that's soft. And their defense attorney doing the job is going to do that. And if they know that the prosecutor's office doesn't go to trial or wants to avoid trial, they're going to get a really good plea agreement, because they know that when it comes time to go to trial, they'll get that soft agreement to avoid, because the prosecutor's office wants to avoid the trial. And we've seen that repeatedly, and especially on a couple of sex crimes that were very disturbing.
Yeah. I wondered about how, because some of the cases I actually do follow,
Mm-hmm.
and I wondered how that process, what the process actually was, and why some cases take so much longer. And it seems like it just kicks the can down the road. And I mean, at what point does a trial become, or a case become ripe for trial?
Well, so basically, once the defense attorney's done all of his discovery work, taken depositions, met with all of his witnesses, and the court asks, is this ready for trial? And the defense attorney says yes. And basically that happens when the defense attorney's done and plea negotiations have stalled out for whatever reason. And then the court will set a trial date and hold the parties to it for the most part.
Okay, because I know there's actual forums out there that teach people how to drop attorneys, change attorneys,
Mm-hmm.
just to keep extending the case.
Yeah,
And
there are some people who do that, some defendants who do that because they like it in the jail a lot more than they would like the idea of going to prison. And I've actually had some clients who were like, I don't care when this gets resolved, because they knew they were going to prison. And they're like, I like it here better than I like prison. So you've got that mentality there too.
yeah,
The criminal mentality is just different from yours and mine.
it is.
It's just very very different.
Yeah. Yeah. I mean, some of this stuff, I think if I even tried it, I would give myself away, like just right out the door.
Yeah. Oh yeah.
So, okay. Okay. You spoke about experience. So please give your specific experience that
Yeah.
prepares you to serve as prosecutor for this county.
So I have been practicing law for over 20 years. I was sworn in October of 2005, started practice at that time. I'd been working for another attorney in town since January of 2004, so I had some experience with the system itself. We actually had a couple of jury trials during that time that I got to sit in on and observe, and those were criminal. I've had several criminal jury trials. I've had a couple of civil jury trials. I'm in court constantly, and I know based upon what I guess when you talk about the hearings I'm involved in, they are like trials. They're mini trials, but you still have to prepare evidence the same way you would for any trial. And you have to make sure your witnesses are prepared. You have to make sure that you've done the research into the law, to the facts, to what your client wants to present, and to advise your client before you go into trial. Hey, this is kind of some problematic evidence. It's not the strongest. Well, we're kind of relying a lot on what you say. So you kind of give them an idea of how the judges will rule, how the case will go down based upon your experience. And like I said, I have countless hours in court prepping for cases, arguing evidence, working with witnesses, and I probably have more actual trial time, case development time, hearing time than anybody else in the field. And thing to remember is it doesn't matter what side of the aisle you're on, you're an advocate. And uh, one of the things that I've said on the campaign trail in one of my videos is that when I'm prosecutor, I want to be successful for the people of Henry County and treat them as my client the way I treat my clients now. And my clients, I'm very zealous. I advocate on their behalf. I advise them based upon my experience about what the chances of their success are. Plus, the other attribute of a good attorney is looking at both sides of the case. So basically, when I go and prepare for a hearing, trial, whatever, I say, okay, if I were the other side, this is how I would attack my evidence. This is how I would attack my witnesses. This is how I would present my case. And so I really have to try both sides of the case in order to adequately be prepared to present my side of the case when it matters in trial or hearing. And I think that experience, that vast experience, is probably what makes me the most qualified of the group, especially since some of them, as I stated, at least one of them has no real trial experience.
Yeah. I heard something interesting recently because I know a lot of people, and I used to be guilty of it, was thinking that criminal defense attorneys it were a special kind of evil because of some of the crimes that they, or some of the clients that they would represent. And I heard someone say that it wasn't about defending the client as much as it was about making sure the state presented their case. And
Yeah.
once I put it in that perspective, then I started seeing criminal defense attorneys in a whole different light.
So one of the funny things that you observe when you're in law school is all those aspiring attorneys all say, well, I don't want to do family law because I don't want to be part of somebody else's problems. I couldn't ever do criminal law because I couldn't defend such and such of a client. And the thing about it is one, all of those people need some kind of help, and you're helping people. And one of the things that I've learned too from the cases that I have successfully defended clients on is that sometimes the state's case, if these people didn't have an attorney, the state's case would result in innocent people being convicted. And to me, my job is not to get a guilty client off. It is to make sure that their rights are protected and that whatever the consequences are not excessive for the crime that was committed.
Right.
And that's kind of my role. My role is a check on the power of the state, which people like until they or their loved ones become the target of it. And that's
Right.
why having tight cases where they're properly developed, properly prepared. I remember when I started practice, Kit Crane was the prosecutor, and we didn't have trials for two reasons. One, his cases were pretty much airtight to where you couldn't win a trial. And then, of course, once you go to trial and reject their plea agreement, you have gotten a more severe sentence. And in the roughly 7 years that I practiced law, that he was prosecutor, I think I tried 2 cases, lost one, and that one we just tried out of desperation. And I won one, but for the most part, we had maybe 1 trial a year because he knew how to develop a case. He knew how to make sure that he, when he or his deputies went to court, that case was a winner, and it was a 95 to 100% winner. And I think that's important, is to make sure that you don't lose cases at trial, because if you do, then that sends that message of weakness that I was talking about earlier. And you can't have that. A weak prosecutor basically attracts crime into the area because people know they can get away with it here, whereas in Delaware County and Wayne County and other counties, it's much more harsh. I know that Hancock and Wayne counties are far more severe than Henry County in dealing with people.
Interesting. I'm learning a lot these days.
Well, that's another thing that kind of helps me is I don't just practice in Henry County. I practice in several counties, criminal law, and I've been able to see what they do that works and what they do that maybe goes a bit too far. But I have picked up on some things that I would implement here if elected that would create a more, I don't want to say a more tough system.
Yeah. Okay, if a law enforcement officer brought forward a case that appeared questionable or involved improper conduct, how would you handle it?
Well, if I became aware of the issue prior to filing, I wouldn't file. Like I said, the evidence never gets any better. The case never gets any better from the day I file it. And if there's questionable evidence, then you can't prove somebody guilty beyond a reasonable doubt. If it's a question in your own mind as prosecutor, obviously, and you don't want to lose the case. So you either go to the detective and say, hey, this evidence is kind of weak. We need to shore this up and make it a stronger case. Is there anything that any rock you haven't looked under? Is there anywhere you haven't sought evidence? And hopefully he could interview more witnesses or something like that and find out. Questionable conduct, you just can't pursue that because you have to assume that a competent defense attorney will find the questionable nature of the activity, and then the evidence gets thrown out and you lose the case, and that's not a good look. And like I said, the big thing is we here have to get away from the soft image or the image where we just can't quite get the ball across the goal line on convictions, and we pretty much have to make sure our cases are tight before we file them.
Yeah. And I think people are looking for, because you always hear the good old boys club.
Yes.
You always hear people refer to that. So I'm thinking that what people would like to see is a system or a process that would work well between the prosecutor's office and the police department and the courts, whereby you don't have cops covering for cops and things like that, where there's I hate to say safe spaces, but you know what I mean. Um, that there would just be a process in place to where somebody keeping their mouth shut was not the best option, I guess.
Well, yeah. So one of the things that I like to emphasize to police officers is that it's a different world. And there was a situation in Muncie several years ago where the police chief's son was also an officer, and he was doing things that were violating people's rights. And there were police officers up there who covered for this guy, writing false reports and doing some other things. And now the officers who wrote the false reports or who didn't stand up, they all face federal charges, and several of them have done some federal prison time. The officer himself, I believe, is doing 10 to 15 years in federal prison. And what I tell all law enforcement when they ask me is like, guys, here's the deal. If somebody would have stopped that guy from doing what he was doing the first time, you might have irritated the chief, but you would have saved that guy from himself, and he wouldn't be going to prison for 10 or 15 years. And you all certainly wouldn't have gone to prison. And the point is that in this world, with the way the federal government looks at police work, you are not helping anybody by covering up for a bad officer. And we've actually seen several officers come to bat when officers have crossed the line. I believe one of the was Aaron Strong did a couple things he shouldn't have done, and he was reported by fellow officers, and then he got in trouble federally for what he was doing. So I think the message is clear, and I don't know personally that police are covering up for each other anymore, because they all know the risk of doing so. It's not just the guy who did the bad things going to get charges federally, but they could get them too for whatever that charge that they have is for falsifying a police report. So I think we've seen a lot of that covering up for each other. I don't think that's an issue much at all anymore, if at all anymore.
I would hope not. I mean, people need to realize there are cameras everywhere.
Yeah, and when
Everywhere.
I'm meeting with clients, I always tell them, if you're in a high conflict situation, whatever it is, civil, family, possibly criminal, I tell them, guys, you need to act like no matter what, you are being recorded at all times, because somebody could be wearing a teeny tiny camera on them that you wouldn't know about.
Yeah.
Or they could just have their phone running while they're talking to you, and you don't know what's being recorded. You don't know what's being memorialized. And if you talk out of turn and you say something you shouldn't say, odds are somebody's going to hear it, and it might be the judge or the jury.
Yeah.
So yeah, I think everybody with the advent of cameras, body cams, and that type of thing, everybody having a camera in their hand, it's just a different world. Bro. I don't think personally that the type of I just don't think that those things are going on anymore like they may have once done.
Yeah.
And I might be naive. I don't know. I just know I see a lot of it in my practice to where body cams are they don't lie. And sometimes they help my client, sometimes they hurt my client.
Yeah. Okay. I've heard some talk about, some people were saying that we already need a bigger jail. Most say we need swifter justice. what types of crimes will you prioritize more aggressively, and what might that look like?
I heard the thing about the jail yesterday. If you want to know the truth, that was the bad part is we were under a federal order for a while, and we might still be about how many people, what the capacity of the jail could be. And so I think that they figured out ways to work around that. The sheriff had mentioned to me a year ago that there were pretrial release options for nonviolent offenders to put them on basically home detention pretrial, but the current prosecutor's office wasn't following through with that the way they should. That would be something that I would look into. I know that director of the community corrections has stated a willingness to participate in that, and she was actively participating in it until the prosecutor's office stopped. The types of crimes that need to be disposed of quickly and get people out of jail are the ones where there's not a lot at stake. You're talking if there's people in there for misdemeanors, if there's people in there for level 6 felonies, if there's people in there for nonviolent crimes, we need to get them on the way. Now, you understand that in a lot of cases, if it's drugs or drugs in the system, we are at the mercy of the Indiana State Police Lab and how quickly they can process the drugs and the blood or urine, as the case may be, and that they kind of will dictate how long things have to sit before they can even think about being tried.
I didn't know that either. Interesting.
And right now, the state police lab is somewhere 4 to 6 months out. Now, if it's an emergency situation, somebody files for a fast and speedy trial, which has to take place within 70 days, they will move you up. But you're always on the drug analysis and blood analysis. You're going to be behind murders, rapes, more serious crimes. And so you're just going to have to wait until those drugs are processed, because that's the official statement on what the substance is and what the weight is. And you have to have that to go to trial.
Okay. All right. Well, that's all the questions I have. Is there anything else you'd like to add?
No, I just think it's time for a change of philosophy. And I think that we need somebody who wants to try cases, who will try cases, who won't put forth the effort and won't shy away from the confrontation of a trial. And I think right now that's the biggest weakness we have, is they're just not trying cases. But there should be a change of philosophy this time, and I would appreciate everybody voting for me, of course, to make that happen. I feel like I'm the most trial experienced lawyer in the field, and I would be able to do that most seamlessly. Plus, I get along with pretty much everybody in that office, and I think the problem in that office is a lack of leadership, not a structural problem that can be corrected through the proper leadership and proper experience.
So in the prosecutor's office, what does the hierarchy look like?
So right now, Michael,
just so people understand how the office structure works.
Yeah, so right now there's the chief prosecutor, then there would be a chief deputy prosecutor, and then there are 2 state paid for deputy prosecutors there, and they're full-time. And then there is right now a part-time county paid level 6 felony prosecutor. There is a part-time county paid misdemeanor prosecutor, and then there is the child support 4D prosecutor. And the child support prosecutor doesn't do any work on the criminal side because she is not allowed to, but she's doing a very good job. Then, like I said, there's of those 5 prosecutors, 3 have little or no trial experience, and that's not a good thing.
Okay. Well, I appreciate you taking the time to do this. It's something new. I know, a lot of voters like my dad and my uncle and older folks, they don't really get out and go to the meet and greets and things like that. But everybody knows how to click a YouTube link.
Right. Right.
So I'm hoping that we can reach a much broader audience and actually let people know what a primary is. I was surprised to find out that a lot of people don't know.
Yeah.
Hopefully we can get a lot more voters out this time.
Well, I appreciate you asking me so I can, talk to you and let everybody out there know what my thoughts and opinions are.
Sure. And I will let you know before the video, before I post the video, but it will be after all of the prosecutor candidates participate and I put them all in one video.
Okay.
And nobody gets the questions ahead of time. So everybody's coming into this cold. And that way everybody's on the same, same playing field and voters get an apples to apples comparison.
Okay. Well, I appreciate your time and I appreciate you doing
Sure.
this. I hope it's helpful for everybody who's voting out there.
I do too. All right. Thank you.
Thank you.
Take care.
You too. Bye.
Okay. There. We're all set. I was there last night, so hopefully this will give you a chance to expand on some of your answers from last night, because even I was getting a little panicked when I would hear that dinger.
Yes, they didn't give us much time to relay the messages that we wanted to. Yeah, I'm not sure.
That's the first time that's happened since I switched to Xfinity. Okay, well, hopefully that doesn't happen again. I'm just getting over a cold here, so I'm struggling just a little bit.
Oh, you're fine.
Okay. First of all, I want to let everybody know when they're watching this in a few days that you are Jeremy Bell, right?
Yes, yes.
And would you like to just introduce yourself shortly before I go right into the questions?
Yeah, my name's Jeremy Bell. I'm running for Henry County Prosecutor's Office. I have do you want me to kind of go through my credentials or?
We can cover that. I
Okay,
mean, if you want to go over it now.
I graduated from Ball State with a political science degree. I went to IU Law School in Indianapolis, graduated May 8th, 2004, was admitted to the bar May 17th of 2004. And since I'm a lifelong Henry County resident, I came back here, opened my private office where I do family law, bankruptcies, general law. I started that in late May, early June of 2004. And then on October of 2004, I was hired as a deputy prosecutor. And for the last over 20 years, I've ran my office doing the bankruptcies and family law, and also worked at the prosecutor's office. So basically working 2 full-time jobs during the week.
Wow, that's a lot.
Yes. But you learn to prioritize what needs to be prioritized and go from there.
Okay, well, the first question I have is, what do you believe is the most important responsibility of the prosecutor?
The most important responsibility of the prosecutor is charging which cases need to be charged and how those cases are handled. Certain cases, you will have to try to get a good plea agreement. Other cases you need to demand a jury trial for, and you have to be able to know which of those defendants need to go to prison and which ones can be hopefully rehabilitated through outside of incarceration services like probation, house arrest, anger management, substance abuse counseling, rehabilitation, things like that. So knowing which cases and which defendants deserve the chance to rehabilitate themselves, and knowing which ones just need to be locked away are the ones that's the most important responsibility of the prosecutor.
Okay, very good. Okay, in your opinion, what would success look like for the prosecutor's office under your leadership, including the effectiveness of the attorneys, the office staff, the support team, and how would the public know it is working?
Well, the success under my term would be that victims feel like they've got justice for the cases that they've been harmed from. That's all victims, domestic battery victims, child abuse victims, sexual assault victims, and even burglary victims, robbery victims, theft victims. Any victim should feel like they've had their chance to see justice done. Um, and that sometimes means a plea agreement, that sometimes means trial. And so being able to see victims have that success and that justice that they deserve would be success under my term. I'm sorry, I can't remember if there was a second part to the question.
Just how,
Oh, how would the public?
right, how would the
W-
public know? Because I think right now, I think there's sort of a breach in communication, and
and
I don't think the public really knows.
And one of my points, if you look at my website and what I said a little bit last night at the Republican Forum, I think I kind of got cut off when I was going into it in my closing, was that I plan to institute my town meeting halls, town meetings, town hall meetings, and invite law enforcement to join those. And I would hold those regularly where the community can come in. We can now obviously we can't discuss ongoing cases or cases that are under appeal, but the community can come in and tell me how they think I'm doing. Because one of the things I've always prided myself on in my mini jury trials, my bench trials, all those, is I've always went to the juries afterward if they were willing to talk to me. I went to the judges afterward and said, what can I do better? Because some attorneys, maybe they've been practicing for 25 years, but they don't ever want to change. They think they know how to do it, and they think they know everything about the law. I don't. I've always asked everybody for constructive criticism so that I can always be better at what I do. And that's why I'm going to, if I'm elected prosecutor, then I will have set up town hall meetings where the community can come in, tell me what they think I should be focused on. Hopefully, law enforcement agencies will join me in these meetings, and so that the community can express how they think we're doing, what needs to be changed, and um, what they would like us to see happen. Now, obviously, again, you can't talk about ongoing cases or cases under appeal, but I could also give, an update as far as why we did offer a plea agreement in a certain case versus taking it to trial.
Right. I like that. Um, okay. Uh, Voters want to know that true child predators are prosecuted aggressively while also ensuring innocent people are not destroyed by false allegations. How would you balance victim protection, evidence standards, plea negotiations, and due process?
So, child cases are very tricky. Unfortunately, most child abuse cases happen in the dark. They happen when it's just the predator, the perpetrator, and the victim or survivor. So unfortunately, there's usually not video, witnesses, things like that in child abuse cases. So you have to have a good investigation done by the law enforcement agencies that are handling those cases. That includes a good forensic interview of the victim, um, and good evidence collection if there are potential evidence like DNA, things like that. But again, most of these cases are delayed reporting because it might be going on for a while before before the child reports. Or, so I mean, in cases like that, there's not going to be much DNA evidence and things like that. It's just going to be, unfortunately, a they said versus they said. So you have to be able to rely on the law enforcement officers to give you a good investigation, give you all those facts, and then you just have to use your experience and determine if you believe this actually happened, and if so, what charges to charge versus if you think there's some problems with the investigation, then you need to be able to send it back to the law enforcement agency and say, hey, these are the things that I see are holes in the investigation. Can you please try to fill them in? And I won't be afraid to tell law enforcement, hey, we need more. We need you to do more. And then as far as plea agreements, I've always, in my 20 years as a deputy prosecutor, I've handled a number of child molest cases, child abuse cases, and I've always been victim first. I follow what the victim's wishes are most of the time. You know, if the victim doesn't want to testify, then we try to get the best plea agreement that we can. Because unfortunately, most 5 or 6, 7-year-old victims, they don't want to testify, or their parents don't want them to testify. Some of them do. But it's hard for a young child to get up in a jury, in front of a jury, in a witness stand, in front of a judge, the court reporter, 12 to 14 jurors, the defendant that they're accusing this of happening against. And I've had cases where I've had to go get the victim ready, and they're having a mini meltdown right before they testify. You have to know how to calm them down. You have to know how to regulate them. And you have to know which ones won't be a good witness. I've had kids that I've tried to talk to in cases like this that just fall apart whenever you ask them the cases. In those cases, you got to talk to the victim and see what they want to do and what's best for them, or talk to their parents and see what is best for them. One of the things I would like to do as prosecutor is get these victims, survivors, into counseling earlier, get some resources for them to have counseling. So because if a child has counseling and before the trial, then a lot of times they can work through all that and get to the point of where they can talk to about these things in front of multiple strangers in a trial. And obviously, if you have a trial, you're going to be able to most likely get a better sentence than if you do a plea agreement. Because a plea agreement, obviously, the defense knows that if you're offering a plea agreement um, that is a drop down in charges or something like that, then they know that there's a good chance that that child witness isn't ready to testify. And so they're going to keep pecking at you and saying, well, what about this? What about a sexual battery instead of a child molest charge? Can we do that? So the defense attorneys can kind of gauge from your actions what the likelihood of being able to go to trial is. Now, sometimes, parents don't want the victim to testify, but we can talk to the victim and work with the victim. And that's why I said, if we can get them counseling sooner, or resources sooner, then maybe the parents will change their minds and say, okay, yes, my child is ready to do this. She or he is ready to confront their accuser, and we're all go. And if we can do that, then we're going to get even better plea agreements or better sentences out of these cases.
Now, because I think there's some confusion too, that when the prosecutor's office tries child molest cases and child abuse cases, that is separate from like a Chin's case, correct?
Yeah, CHIN's case is what's called, it's called a CHIN's case, but CHIN stands for Child in Need of Services. And those are children that DCS has determined that they are not being taken care of by their guardian or custodian or parents. And that's where kids are potentially taken out of the home by DCS and placed in foster care. Now, a lot of times those cases might go hand in hand because the chins might be that they were need to be taken out of the home, detained out of the home for their safety because a parent or a guardian is abusing them. So you can have a child molest case or a child abuse case where there's a separate criminal charge that the sorry, that the perpetrator was charged criminally, and then you can also have a chins case, and a lot of times those go hand in hand because there are most of the times a good chance that it's that if a child is being molested or abused, it's somebody in the household. We get very few cases where it's a stranger that abuses a child. Usually it's somebody they know, it's somebody that they've been groomed by, and usually that's a parent or a guardian or a close friend or some relative. So those two cases can go hand in hand, but Chin's cases are handled by DCS.
Okay. Because I think a lot of people think that when a child molest case goes to the prosecutor, that CPS and the prosecutor's office work hand in hand. But once it passes to a CHIN's case, then that goes prosecutor's hands and into CPS, right?
Well, so let's say that somebody reports potential child abuse. There has to be, if it's reported to somebody that's in authority, then there has to be a hotline call from DCS has a hotline number to report any potential child abuse cases. And then that would go to DCS and usually would also go to the police agency that would be responsible for the investigation. So DCS does their own investigation, and DCS, when I say that, I'm referring to the Department of Children's Services.
Okay.
So DCS would do an investigation on their own, and they would either substantiate or unsubstantiate the allegations. The law enforcement would do a separate investigation. Now, they usually work hand in hand together. And so one of the things that happens in cases like this is the child would be usually set up for what's called a forensic interview, where the child goes into interview with a specialist that has been trained to interview children. And usually in those cases, DCS is there monitoring the interview. A law enforcement representative is there monitoring the interview. And but the child only interacts with the actual specialist and interviewer, but usually they have an ability to stop the interview and go ask questions, or they can, most of the times they have a little light in the room that they are doing the interview, a little red light or some kind of light that indicates that somebody that's monitoring the interview has a question that they want covered. So there's both investigations go. The law enforcement investigation would then be referred to the prosecutor's office, where the prosecutor's office would refer it. And generally, we would also ask potentially for any DCS documents. But then, so the prosecutor's office would review the law enforcement investigations and then decide whether criminal charges are going to be filed against the accused person. DCS, if they substantiate the allegations, then generally that's when they would file a Chin's case, determining if the child needs to be detained from the home for their safety. Now, not every child abuse case is going to have parallel cases, because sometimes, a lot of times, the DCS case would be unsubstantiated and the department would no longer move forward on their case. But the prosecutor's case could still move forward, even if the DCS case is unsubstantiated, if the prosecutor believes there's enough evidence to find the person guilty beyond a reasonable doubt. If we think we have enough to prove that to a jury. So now there is some legislation that has been talked about putting DCS under the wing of the prosecutor's office, but that has not happened and may not happen, but it also might happen. And in that case, then the prosecutor office would handle both cases with DCS working under the wing of the prosecutor's office. So
Do you think that would be a good thing?
that's a tough question.
Yeah.
I do think it would probably be a good thing in that then all the resources would, because obviously DCS works with limited resources, the prosecutor's office work with limited resources, and with the property tax issues, there's probably going to be less money for those offices. And so if you could combine, and I believe that's the thinking behind the legislation, is if you can combine those offices and those resources, then you're going to have a better ability to investigate these things. But it also might mean that, unfortunately, already busy prosecutors and DCS attorneys might get cut down, and there might be more work on on the prosecutor's office to that will delay justice for other victims.
Yeah.
So I mean, if if resources increase or stay the same, that could be a good thing. If resources are cut down, then that's going to hamper investigations that already work on a tight budget.
Yeah. Interesting. I didn't know about that. I'll have to keep an eye on that. Okay, the next question. Give us some detail about your specific experience that prepares you to serve as prosecutor for Henry County.
My specific experience is obviously that I've been a deputy prosecutor for over 20 years. I've handled all aspects of criminal cases, from reviewing them at the outset, charging them, the defendants with the charging information, which is the official document that is filed with the court to actually charge a defendant. You have to review the police report, the law enforcement investigation report, determine what charges should be filed, what evidence you have. I've done all this for 20 plus years. And then I've actually had jury trial experience where I've prosecuted. And there's a difference between having experience and prosecutor experience, because the prosecutor, like any defense attorney is going to tell you in a trial, is the one with the burden to prove beyond a reasonable doubt that the defendant is guilty of this crime. The defense attorneys, and all my jury trials, the defense attorney at least once, if not multiple times, has told the jury, I don't have to prove anything, that the defense attorney doesn't have to prove anything, that the defendant is cloaked in a veil of innocence until proven guilty. So there's a difference between having that experience and knowing what you need to prove somebody beyond a reasonable doubt is guilty of this crime, versus sitting there and just trying to poke holes in the prosecutor's case. So I've got that experience. I've tried numerous jury trials. And like I said, I've only ever got one jury trial that I did not get a guilty verdict in. And that was my very first jury trial, and it was a misdemeanor charge. So I didn't have the experience I have now. But since then, I've worked to make myself better prosecutor, better trial attorney. And I think the numbers show that I've been able to get a guilty verdict in every jury trial I've had since then. And that's a number of jury trials, including child molest cases where the defendant got 110 years Department of Correction sentence, sexual misconduct cases, robbery cases, battery against a public official case, escape cases, numerous other cases that I'm not going to sit here and bore the
Right.
viewers with. But also in my specific experience, like I said, I've ran a civil office for over 20 years also. So in that, guys, I had to and train staff. I had to work on and balance my own calendar. I had to know how to run an office, do all the administrative things, work on a obviously when you're running your own small business, the more you pay out in expenditures, the more you spend on things, the less money you're making.
Right.
So I know how to work with limited resources. At my office, I've set up or had set up a case management system out of very few expense, where that case management system would remind you of what needed to be filed. So what the deadlines were for certain documents to be filed. Most of what I did in my office was bankruptcies, which as a Chapter 13 case in a bankruptcy can last for 5 years. During that time, you have to file specific documents at certain points. So you can't try to remember all that. You have to have a case management system that remind you of those dates and those filing deadlines. And that's one of the things I'm going to do that, unfortunately, as the prosecutor's office right now doesn't really have a case management system that we work with. A lot of it is just done on an Outlook calendar, and I plan on changing that. I'm going to work to get a case management system that gets us deadlines so that there is no problem with discovery going out, and that we can say discovery went out this time. And so a defense attorney can't complain that he hasn't got, or he or she hasn't got discovery and delay the case, because then we will have the notice of saying, hey, it was provided to them on this day um, within the deadline. So they can't ask that evidence be excluded because that it wasn't timely given to them.
I wondered how that worked because I had heard that uh there was a break in communications, in the flow of communications from the prosecutor's office to defense attorneys and that the current office is operating on an old system is what I've been told.
Yes. I mean, unfortunately, it goes back to those limited resources,
Right.
and we work with a fairly older system. Now we are trying to improve that, but if I'm elected prosecutor, that will be one of my focuses, is to improve that procedure so that the attorneys, because there's the elected prosecutor, and currently there are the chief deputy, and then there's three other deputies that cover criminal cases. And one of the things that happens right now that I would like to change is calendar invites for hearings go out to all parties. So then that can be put on wind up on multiple attorneys, prosecutors, deputy prosecutors' calendars. And so then you might have two deputy prosecutors showing up at the same hearing thinking they're covering it, and that's just a waste of time. We need
Right.
to focus that down to the staff getting the Outlook calendar invites, and then putting them on the right deputy or the right prosecutor, chief prosecutor's calendar, so that they know what they need to do on those days, where they are expected to be, and also when they are expected to have those deadlines for filing documents done.
Interesting. I'm really learning a lot through this process. I'm enjoying this actually.
Well, that's
Uh,
one of the things I always prided myself on when I talked to my clients at my private office, is that they went out from knowing exactly everything they needed to know. And that's why I would spend, hours with a client at an initial consultation, because I want them to be able to make the most informed decision that they have. And that's the same way with the voters. I want them to have the most information that they can make the informed decision, because basically what the voters are doing in this election is hiring the attorney that they think they would want to work for them if they were having to pay for the prosecution of a crime that they were a victim of out of their own pocket. Because essentially they're paying their tax dollars. Those tax dollars pay for the prosecutor's office. And that's why I believe that the public should be informed and the public should know what we are doing.
Right. I agree. Absolutely. Okay. Henry County is known to be in the news. If a law enforcement officer brought a case that appeared questionable or involved improper conduct, how would you handle that?
Are you talking about improper conduct from a law enforcement officer or
Yeah,
improper conduct?
because I think a big concern is people feel like a lot of things have been swept under the rug, ignored, or just kind of blown off, and until it just turned into this.
Okay. Yes. So what I would do is I would ask that the state police or another outside um, department investigate that's allegation. So I don't think that the department that law enforcement officer works with should be the one investigating it. First of all, so that would fall with the Indiana State Police because they are the department that normally investigates other allegations of misconduct in another law enforcement department. Um, and then I would just look at the facts. I mean, look at the investigation. If I had questions, I would call the detective that is handling that investigation and ask them these questions. Ask them if they've got any evidence that would fill those holes that I have questions about. And then if I still have questions about the investigation and the detective has said, I've gotten everything that I can get, but I still have questions, I would take it to a grand jury. That's generally not done most of the times in Henry County. I think it's been done once or twice the entire time that I've worked at the prosecutor's office. Over the past 20 years, I can recall maybe one or two grand juries. But those grand juries would be citizens of Henry County. It's a sort of a mini jury trial where you lay out the evidence and then ask the grand jury members to either say, yes, we believe there's enough evidence to charge this person with this allegation, or no, we don't. So you kind of get a test run. Now, there's a lot of different rules as far as, doing that and who can be in the know and who can't be in the know of that. You have to give the defendant a chance to know that they're under investigation, which obviously if there's a law enforcement investigation, then they already know that. But yeah, that's how I would handle it because I'm not going to be, I'm not going to allow things to be swept under the rug. But I also understand that there are cases where there are allegations made against officers that are made against people just because they don't like that officer or they feel that officer handled things. And obviously with social media now, a lot of people will record things, but just because it's being recorded doesn't mean that's the full story of what happened. We got to get all the facts and make a determination by the facts only, not by public opinion, not by social media feeds, podcasters, things like that. We have to go by the facts and
Right.
let the facts drive the investigation and let the facts drive any criminal charges that result from the investigation.
Absolutely. Okay, last night I heard, and I asked this question of other candidates, and I thought it was interesting that it came up again last night. There's been some talk about a bigger jail already. Most say we need swifter justice. We don't need a bigger jail. So if you're elected prosecutor, what would you do going into that position? How would you prioritize cases and handle them most aggressively?
So, I mean, if I'm elected prosecutor, one of the things that I will probably do is obviously I've talked about the case management system so that the discovery gets out in timely manner, which I believe in most cases it already is going out in a timely manner. But we need something to be able to know when it was done and when it needs to be done. So I would set that up. Then I'm going to um, probably I'm going to set a deadline, probably a year, and saying if the case has not been resolved in a year, then we need to set it for what's called a first place setting. And you might see if you ever look online at my case or DocsPop or one of those websites that list county charges, court calendars, you might see that a jury trial has been set in a case, but a lot of times that's not a confirmed jury trial until it's set for what's called a first place setting, and that is where your parties are telling the court, yes, this is the date we want to go to trial at. So I will probably put in a deadline of a year in most cases, that if the case hasn't been resolved by then we need to ask for a confirmed jury trial and just go forward with it at trial. Now, a lot of times it's not the prosecutor's office that are requesting these continuances. A lot of times it's the defense attorney, and that's where, us being able to say, okay, discovery was sent on this date. This is the date you downloaded it from the e-discovery website, that we can say, okay, you've got everything. We need to make sure we can say that so we can tell the court that, look, they've got everything we have. This is the time. The case has been dragging on. We need to get it done. Unfortunately, the other issue with the that affects this is that disregarding misdemeanors and infractions, which infractions are speeding tickets, disregarding a stop sign tickets, things like that. So disregarding misdemeanors and infractions, just including felonies, so level 6 felonies through level 1 felonies, there's about 500 to 600 cases filed a year, criminal cases in Henry County. About 400 to 500 of those are what's called level 6 felonies. That is the most minor felony that you can have, with level 1 felony being the highest level felony that can be charged outside of murder. So there's probably 100 to 200 major felonies. What I consider a major felony is a level 5 felony up to a level 1 felony filed by the prosecutor's office a year. Now we've got 3 courts, 52 weeks out of the year. So that's roughly 156 weeks that we could have a jury trial in. So if you're having 100 to 200 major felony cases, so level 5 to level 1 felonies filed a year, that's going to take up most of those courts, and not all courts handle major felonies. Those cases are all generally handled in either Circuit Court 1 or Circuit Court 2, with Circuit Court 3 handling about half of the level 6 felonies and all the misdemeanors and infractions, along with their civil cases. So part of it is just we don't have, with that many cases, you don't have the time to take every case to jury trial. So we have to do plea agreements, and we have to prioritize trying to get the cases that are slam dunks, the cases that are what a lot of people refer to as the Cadillacs, done with plea agreements, because those are the good cases. And generally those cases don't go to trial because the defendant knows that there's a good chance that they are going to get found guilty. So they just look for try to get the best plea agreement. That's where we need to be more forceful on our plea agreements. And I've always been very forceful and try to get the highest amount of jail time out of defendants and plea agreements that are possible. And I'll tell you a little story. I won't divulge the defense attorney that sent this, but we used to have a chief deputy named Richard Culver in our office. He's since retired, and this was a few years ago, but he sent out a plea agreement that called for a very long sentence in a case. I believe it was a level 2 felony, and he was asking for about 25 years. And this defense attorney got, and this was relayed to me by Mr. Culver and the defense attorney themselves. The defense attorney got the plea agreement and sent back an email that said, "Jeremy, what are you doing at Rick's desk? Because I've been known to ask for very high plea agreements." And so that's how defense attorneys see me. They see me on a case, and they know that I'm going to ask for a good, healthy sentence with to get this defendant off the streets.
Yeah.
And I sidetracked myself, and now I forgot the question.
That's totally fine. I like knowing that, harsher plea agreements are a thing, because I think a lot of people have seen too many soft plea agreements. And I think we all know that child predators, I mean, I guess science says it's a sexual preference. It cannot be rehabilitated. So
Yes.
um,
And one of the things that I'm going to change is that every plea agreement for a major felony, so a level 5 through a level 1, every plea agreement is going to have to be approved by me, no matter who the deputy prosecutor handling it is. So from the chief deputy down to the deputy prosecutor that handles the minor felonies, every plea agreement that they offer is going to have to be signed off by me, making sure that that is a plea agreement that I agree with, that the defendant is getting the most harshest plea agreement that we can get in that situation.
I like that, because it just seems like the soft plea agreements are, it seems like a lot of times they further victimize the victim. And, I mean, some of these cases, they get drug out for 2, 3, 4 years.
Unfortunately, yes.
Yeah. And victim continues to be victimized. And then if it ends in a soft plea agreement, it's like, where's the justice? So I do like the hard plea agreements from the start.
And unfortunately, I'll be honest, there are probably plea agreements that I've handed out that might look soft, but I've never done a plea agreement that was not with the victim's consent. I always try to get the harshest plea agreements that I can out of a given case, but I've always asked the victim if they are okay with it, and if the victim is comfortable with it, then I will be comfortable making that plea agreement offer. And unfortunately, because I have practiced as a deputy prosecutor for 20 years, I've tried, I've handled numerous cases. I've handled probably a 1,000 major felony cases. So I mean, I'm going to have good sentences like the 110 years that the child molester got to the DOC, and I'm going to have cases that people can find that I offered a sexual battery level 6 felony to a predator, because that's what the victim kind of was comfortable with, and they were okay with that given the circumstances of the case. So I mean, that's the only thing, and I don't hide from any of my record. I mean, if anybody wants to ask me about any of my cases, as long as I can talk about it and divulge what I can, then I will talk about it. But one of the things I try to do in cases like that is offer what's called an open plea agreement. So that's a plea agreement where the sentence is determined by the court. So the prosecutor gets to make arguments and present witnesses as to what they believe the sentence should be. The defense counsel gets to make arguments and present evidence as to what they believe it, and then it's determined by the court. So I mean, in cases like that, that allows the victim or the victim's family to make a statement to the court saying, this is what I believe should happen. The defendant is given the chance to make their statement and explain why they should be given probation or home detention or whatever they're asking for. So that's one way that I tried to handle cases where we can't come to a resolution, but we don't want to try the case and the defense counsel doesn't want to try the case.
Yeah.
So that's one of the tools that I've always used. But yeah, I've got an extensive history of of handling these criminal cases. So there's going to be cases that look like they were soft plea agreements, but like I said, I've always just worked with the victim as to what they're comfortable with,
Yeah.
given the facts.
Yeah. Well, that's all the questions I have. So if there's anything else you would like to add, that you didn't get to say last night, feel free.
No, I mean, I think we've talked about everything. Like I said, I've got the experience that was required to do this. And I guess one of the things that I really didn't get to cover is last night, or we've talked a little bit about today, is that with that experience, I know what it needs to be done. Like I said, that experience prosecuting, because working as a family law attorney or a criminal defense attorney, you don't really work with the victims of crime, and you now have to know how to handle that approach, and you have to know, especially with children, how best to approach them and get these things talking about. And you don't get that with family law cases or civil cases. So it's a different aspect of practicing law, where you have to be able to comfort and regulate these children or victims, because they're dealing with probably the worst thing that's ever happened to them in their lives, and they're going to have to live with it for the rest of their life.
Yeah.
Unfortunately, you know, me or whoever else is handling the case, if it's an attorney, we go on, we live our lives, and we don't really generally look back at those things. Whereas this is going to be a defining moment with this victim survivor. And so you need to make sure that they are comfortable with you, they are comfortable with the outcome of the case. And it takes time to build that relationship. That's why generally most of the times when I'm handling a case like this, I will meet the victims, survivors, for 2 or 3 times before I ever even start talking about the actual facts of the case. So I try to build that relationship up. Now, obviously, in some cases that doesn't happen, because the child or the survivor or the victim doesn't want to talk to anybody about it. And those are the cases that, unfortunately, do get plea agreements granted to them. And so, I mean, that's the only thing I would like the voters to understand, is that it's not as easy as saying that making a campaign promise of saying, I'm going to go in and make sure that child predators get the max sentence. Because in order to do that, you would have to potentially, in some cases, you would have to force a victim that is not wanting to testify to get up on a stand and recount the worst day of their life, most likely, and re-traumatize them. So that's one thing that we have to do, is we can't re-traumatize a victim that doesn't want to go forward at that time. And so sometimes that means even dismissing the case and maybe refiling it later when that victim is prepared to go forward, if it's at least within the statute of limitations.
Yeah. Yeah.
So
Okay, well, that's all the questions I have for the voters for the general. But I would like to get in touch with you and set up a time when I could talk to you privately, because I truly am undecided in the prosecutor's race.
Okay.
And I want to know that I'm making the best decision. So I take my vote very seriously.
As you should. I mean, because like I said, you're voting for the person that you believe that would represent you the best if you alone was being represented by that attorney.
Right. And I have spoken with 3 of the candidates so far. So I would like to set up a time to speak with you privately for my own questions. So
Feel free, got all my information.
I do.
So yeah, feel free to reach out. I think I gave you my cell phone number.
I think it's on where I had to sign up for the appointment
I
for
think
today.
so.
I think so.
I think so. It was
Yeah.
either my cell phone number or my private office number. So just
Okay.
reach out
Okay.
to me through those, or
Sure.
email's fine. And we can set up a time to talk.
Okay. Sounds great. Well, I appreciate you taking the time to do this. And um, every candidate got the same exact questions asked,
Okay.
and nobody got them ahead of time. So I wanted, because I know in the debates, they ask the one question and then everybody gets to answer it.
Yes.
So it feels like by the time you get to the end of the line, it's not a unique response.
Yes.
So in this way, I wanted the voters to be able to compare apples to apples, and
Yes.
everybody has access to a YouTube link. So
Okay. Yes. Unfortunately, in those debates, a lot of times, one person says the answer and then everybody else pretty much says the same answer. So yeah, unfortunately, and also the time limits on those things,
right,
unfortunately, don't give us enough time, any of us, to really um, get a real answer out. It's very
right,
bullet point answers.
yeah,
So yeah, unfortunately, those don't aren't the best ways for voters. It's one of the ways to reach the mass of voters, but not one of the ways that for the voters to be the most informed about our
right.
party's positions.
Right. Well, I hope this is just the first year that I've decided to try this. And since I'm a nerd, I thought I would, give it a go and see if we can do something with it. And I'm hoping that it'll encourage people to check their voter registration, because I'm trying to get it out this weekend before the deadline for them to check and verify their voter registration or to get registered to vote, and to let people know that a primary actually exists, because a lot of people don't even know
Yes,
that. So
yes,
hopefully it'll increase voter turnout, and hopefully it does something positive this year for our primary election.
hopefully so.
Yeah,
And I appreciate you doing this.
sure. I'm glad to do it. So, and I will be in touch.
Okay,
All
have a
right.
good
Thank
day.
you very much. You too.
Bye.
Okay. All right. If you want to just take a minute and introduce yourself, since you were cut so short on time the other night.
Sure. So I am Christi Brock. I'm running for Henry County Prosecutor. I worked in the prosecutor's office for about 10 years. I really enjoyed the work there. I left the office, though, about 2 years ago. Since that time, I have been working as an attorney at Defer Varan Law Firm here in Newcastle, Indiana. So I'm just very excited to have the opportunity to serve the people of Henry County.
Awesome. Okay, first question I have is, what do you believe is the most important responsibility of the prosecutor?
Okay. So, as I've been preparing for this endeavor of campaigning and deciding whether or not to run for prosecutor and thinking about what might happen if I am successful. I have spent a lot of time going around and talking with residents of Henry County, with law enforcement in Henry County, with people in supporting agencies and groups. And I know some of the reasons that I ran. And one of those being is victim advocacy as a prosecutor is very important to me. And I have a lot of experience working with victims as a deputy prosecutor. And that's the primary reason I decided to run, but I also wanted to hear from others about what they see could be improved upon in the prosecutor's office from where it's at right now. So I would say the number one issue that I think the prosecutor's office is facing currently is a lack of good, healthy communication with lots of different people, with lots of different agencies. And I think that that's something that needs to be improved upon. I think that we need a prosecutor who can communicate with law enforcement, who can communicate with victims, who can bring in collaborations to help support the victims and the processes of the prosecutor's office. And so that's something that I would make my priority. I think that in terms of victim advocacy and communication, a concern that I have right now that I have heard from people within the community is that I'm not sure advocates, I'm not sure if the prosecutor's office is making immediate contact with victims in cases and including them in the process of prosecution of the cases. And I think that's one of the most important things that we can do for victims. I think that victims, the first thing that they do is they lose their voice. I think that's part of the crime that's committed against them. And then I think it's a common problem. It's not just Henry County. I think it's a common problem across the country that the justice system has a tendency to, in some ways, keep them down or further victimize them by not allowing them to have a voice in their own prosecution. And ultimately, the decision lies with the prosecutor as to how to handle a case. But I think that the victim also needs to have a voice. And so I think that the very first thing that needs to be happening is we need to be making contact with those individuals right away. We need to be establishing critical touch points during the course of a case so that we are working with them and communicating with them throughout the case. We know how they feel about things, what they want. We're talking with them. We are building trust with them. We are being very honest with them about the strengths and weaknesses of their case. Don't hold anything back. Don't hide anything from them. Let them know truly what your assessment of the case is and let them have a voice in what the outcome is going to be. I think that you have to be able to do that. I think we all agree. I think all of the candidates agree that we want to get the toughest sentence possible for our victims to give them justice. I think that's a pretty common sentiment. But I also think that it's a nice sentiment, but you have to be able to actually follow through on that. And I don't think you can follow through unless you can get a victim to the point where they trust you enough that you can take them into a courtroom that's a very intimidating atmosphere with a judge, with a group of strangers who are going to be evaluating everything that they say. And also the offender will be in that courtroom as well. And they have to feel like they've got trust with you, that they can go into that room and talk about the most traumatic moment of their life. And if you can't do that with them and get them to testify, you're not going to be able to get a conviction. And if you can't get a conviction, being tough on crime doesn't matter. You have to be able to get that testimony and get that conviction. And so I think that's one of the most important things in terms of communication that we need to work on and relationship building. I think the next issue that we need to work on is communication and relationship building with law enforcement. And I know that makes some people nervous sometimes because they think what I'm saying is we need to rubber stamp law enforcement. And that's not what I'm referring to. I'm referring to more of a professional partnership. We have to be able to work as a team. We have to be able to rely on one another. I think it's very important to set clear expectations for each other. From a prosecutor standpoint, I want to set clear expectations on what I expect in a case. If I get an investigative report from law enforcement, I want to be able to look at that and let law enforcement know, hey, I think this is great, but we still need X, Y, and Z to make this a strong case. This is missing from this case. And this is why I need these items. We need to be getting to those investigative reports in a timely manner. We can't let them languish on our desks. We need to, I think one thing that's really important, I know some law enforcement, I know there are some people who are frustrated with case outcomes, I think in the public and with law enforcement. But I think even more than being frustrated with the case outcome itself, what is very frustrating is that I think in some situations, law enforcement is finding out about a case outcome that they have worked on after the outcome becomes public. So they find out about it through social media or through the newspaper. And so they have no idea why the outcome is what it is. And I'm not sure the public always knows why the outcome of a case is what it is. And so I don't know if the issue is always, sometimes it is that we are upset with the sentence. We look at it and we think this seems too lenient. But I think an even bigger issue is that there's no explanation or discussion or transparency about why this happened. And so sometimes there are going to be end results that maybe everyone doesn't agree on. Maybe law enforcement and the prosecutor, maybe they don't agree. Reasonable people can disagree with each other. That's pretty common. But I think the bigger issue is just being able to articulate why we're making those decisions. It's not just good for law enforcement, it's good for the prosecutor as well to sit back and go through this and think, well, why did I make this decision? And to be able to justify what that is. So I think that's really important. I think that more education, more legal guidance is really important. I think law enforcement wants that. I don't think that they want to just be trying to make decisions that are unfounded. So I think having that teamwork is really important to bring back. I think in terms of the office itself, making sure, I know one frustration that I think I've heard from some of the court offices is that I think that sometimes there seem to be a lot of mistakes taking place in some of the information and documentation that they receive. Now, I think that is that you can't ever get rid of any of that. None of us are perfect, but I think making sure that office staff has adequate training, I think that's important and needs to be addressed, and see where people are at there. And that's not at all on office staff. I think the prosecutor's office has an amazing staff, but I think the oversight has to come from the prosecutor. That's where the buck rests, right? And then I think that we need to focus on trial readiness. You need a prosecutor. Now, I say you need a prosecutor who is fearless. I always say that. That doesn't mean that going to trial is easy by any means. It just means that you have to be the type of person who is ready to put the time into really preparing, working with victims, working with expert witnesses, going through the technology, making lots of notes, writing out what you think arguments might be for your case, just getting everything together and researching the law, and being trial ready, so that you can if it comes to it, be ready to go to trial to get the outcome that you need. And if you don't go to trial, you're still going to get a better outcome, even if there is a plea deal that should happen to take place, because you're coming at it from a better position, right? So I think there needs to be a balance between trials and plea deals. I will say it's hard to evaluate without getting a lot of information from the current prosecutor's office, but it does seem to be a little bit of an imbalance from an outsider looking in. And so it's something that I want to make sure that there's balance there.
Well, that kind of touches on the next question, which is in your, and this is totally in your view, your perspective, what would success look like in the prosecutor's office under your leadership, including effectiveness of attorneys, office staff, support team, and how would the public know that it's working?
Sure.
Yeah.
So for me personally, as I've mentioned, victim advocacy is so important, but then trying to translate that and success into a metric is something that I've given a lot of thought to. So I know the first place a person's mind goes to is, should we monitor convictions, the number of convictions and what we're getting out of that? I'm not saying it's something that should be tossed aside. I think it's part of like the overall picture, but I think you have to be careful about placing too much value on conviction rates, because then I think you could find yourself with prosecutor's office that cherry picks cases. They aren't willing to maybe pick up tougher cases, which a lot of cases where you maybe have a sexual battery, maybe one person's word against another person's word, and those are tough cases. Or child molest cases are very tough. A lot of times, unlike what you see in television, there isn't a lot of DNA evidence. It's usually at some point, maybe a year after an incident occurs, a child all of a sudden discloses. And so what you have is the word of this child against the word of the person that's being accused. And so you want to make sure that you've got a prosecutor's office that's willing to go after some of those cases. So conviction rate is a little bit tricky, just like measuring recidivism. I think that is a good thing to consider, but there are so many factors that impact that. What I think could be an interesting way to help monitor success in the prosecutor's office is with law enforcement. Maybe we should start tracking, okay, when did an investigation hit the prosecutor's desk? And then how long did it take for the prosecutor to respond to that officer about that investigative file? Maybe we need to be tracking that. How long did it take for charges to be filed or for the case to be said, nope, we're not going to pursue this? And if it took a longer than usual time, is there a reason for that? Did the prosecutor then within X number of days or X weeks, did the prosecutor get back in touch with that office and say, we need more, this isn't where it needs to be yet? And tracking some of those timelines, I think that would give some transparency to the office that the public would appreciate. I think tracking the number of contacts, like I said, finding those touchstone moments during a case and saying, these are places where the prosecutor should be touching base with law enforcement. Has the prosecutor done that? I think that could be an interesting thing to track and to be able to share that with members of the public. I think how often did the prosecutor's office collaborate with law enforcement on warrants? How often did the prosecutor's office provide legal guidance to a law enforcement agency? I think that those are all helpful to understanding what the relationship is. I think when it comes to victim advocacy, you can track some of the same metrics. From the time that you receive a case that involves a victim, how long was it before the prosecutor on that case or a victim advocate within the office reached out to that victim to help tell them about what the process is going to be? What are the important touch points in that case? And did the prosecutor make contact with that victim at those specific touch points during the case? Did the prosecutor get back in touch with the victim at the end of the case and help them write or put together a victim impact statement so that they understand that they can go into court at the end of the case and let the judge know how they feel about how the case was handled and how the prosecutor did? I think that those could all be very interesting metrics. I think giving victims the opportunity to write an anonymous survey if they want to. I think that could be a good metric as well. I think that will help show, are we making an effort to build those relationships and that trust? And you need to measure it while you're going through the case. Once the case is concluded, it's very rare that you hear back from a victim because you are associated with that individual. It's like the worst time of their life. I think that a successful office, I think the prosecutor needs to think about hiring individuals who can maybe complement their weaknesses. For example, I want to make sure I have someone who can help me with the technology side of things in my office. I want to make sure that I have an office investigator who can help me by being a liaison between myself and law enforcement, who can help me navigate, okay, is this procedure that they're utilizing, is this the best procedure? Are they using best practices? How do you think I should handle this situation that I feel like I'm concerned that we could have done this better? Can you help me find effective training to recommend? So having people who can fill some of those niches, I think, is very helpful, very important. Someone who you feel comfortable bouncing ideas off of in cases, because, there's never just one right way to approach a case. And so being able to share some of those thoughts about things is helpful. I think it's important also to make sure that you surround yourself with people who you not only trust, but you trust will call you out when you're not handling things the way you should be handling things. And sometimes, okay, lawyers have big egos, right? And we like to argue that we are right. And so I want to make sure I have someone in there who can say, Christi, nope, you're messing up, or Christi, you overlooked this, with both my office investigator and both my chief deputy, whoever that ends up being. And sometimes I think we make the mistake of finding people who just make us feel comfortable. And I do want someone who can be trustworthy. I know Scott Pinkerton, he was the office investigator in the prosecutor's office for much of the time that I was there. And I really respect him as someone who does have a good moral compass. And so I know I've talked to him a little bit about, thinking about what characteristics I need to look for in my next office investigator. And he always says, I just want to make sure you have someone who is godly. And I think that's his way of saying you need someone who has that good moral compass and who really wants to stick to doing what's right. And I appreciate that. That's definitely what I want to find in a person.
Very good. I like that. Okay. Voters want to know, because I did reach out to a large segment of the community to get ideas for questions to ask.
Great.
A lot of voters want to know that true child predators are being prosecuted aggressively while also ensuring innocent people are not destroyed by false accusations.
Mm-hmm.
And how would you balance the victim protection and due process?
Sure. Okay, so it's a good question. I think, first of all, I think it's a great sentiment, again, that some of our, my fellow opponents have. I think it's a really good sentiment that no predators get probation. I think that's a really great idea. I think I don't know that that's a promise that I can make. I think that we need to prosecute these cases aggressively. I think that, again, being part of a team with your victim, you want to make sure that you aren't further traumatizing your victim. However, you definitely want to make sure that you are building this trust with them and supporting them and encouraging them so that through the process, they feel more and more empowered. I think that's the part that makes me feel good about being a prosecutor. It's very challenging dealing with these types of cases because I had a case where I had a 6-year-old and an 8-year-old in a child molest case. A case never goes to trial right away. It's very rare. Usually it takes at least a year before a case gets to trial. And that's no fault of anyone in particular. It's a combination of different factors that tends to lead to that. And once you discover that there is some sort of abuse taking place, it usually comes to a stop. And so now you've got these children who no longer have this harm that is occurring. And now we're asking you to come in and remember this harm and keep it in your mind and keep reliving it so that I'm able to have you testify about this. And so it was, when I started doing this job, it was a real hardship for me to feel like I might be re-traumatizing these children by having them constantly come in and go back through these events. And so I worked hard meeting with special forensic interviewers who are trained in forensic interview, with therapists and counselors who deal in all of this, and with advocates at places like Safe at Home, to help me figure out ways to work with children and victims from vulnerable backgrounds. Adults, it's not much easier for them, right? So that I feel like I'm doing the right thing for them and not causing more harm. What I found is if you take it slow and you start from the very beginning, from day one, taking it at their pace, getting them to the place where they understand and talking about it, that they are gaining that power back that someone else has taken from them. And you take turns with things, especially with kids. One day I have them come in and I play a game with them that's a cooperative game where you might win, you might lose. I don't let them win. We talk about what it means when you lose and how that makes you feel. And we're in it together. If we lose, we both lose. Does that mean that they didn't do a good job of playing that game or with what they were doing? Does that mean that I don't like spending time with them doing those things? No. So you kind of go at it from their level. And then maybe the next time you let them know, we're going to talk about some more serious things when you come in the next time. So they always know what's coming next. You go through all of that. Building that trust so that you don't feel like you're being too hard on them. And it gets them to a point where you do see things like, because I want them to have a voice and feel empowered, like with those girls in particular, I had given them self-addressed letters. And it was such a surprise to me one day. I said, if you ever have a problem, if there's something you're concerned about, you can stick a letter in the mail to me. And one day I got a letter from the 6-year-old in 6-year-old writing language that said, I would like one more nice day with you before the next hard day. And that meant a lot to me because it made me feel like I have given these people a voice. These children have a voice in how we are pursuing their case. And it may not mean that they want to have that hard day, but they feel like they understand what this process is. They understand that they can trust me to help them through that hard day. And then when they had to go in the courtroom and testify and they weren't allowed to have their mom or their dad in the courtroom with them, they knew that they could just look directly in my eyes and not look at anyone else and try to make everything else go away and talk about what happened and feel like they weren't embarrassed about it. They didn't feel like it was their fault anymore, that they could do that. I think in terms of making sure that you protect defendants' rights or potential innocent individuals' lives, you know, it's tricky because what my job is as a prosecutor, if I would be elected, is to look at a case and to ask myself, is there probable cause here? And in determining probable cause, you're saying, could a reasonable person look at the evidence that we have in this case and say, yes, I think that this crime occurred, and yes, I think that this person did it. It's a lower standard than the standard for actually getting a conviction, which is proof beyond a reasonable doubt. And I take the standard for charging very seriously, but I also have to make sure I do protect my victims. And so when I make that charge, I may not be 100% certain. Even when you ask for a conviction, you're not going to be 100% certain. Proof beyond a reasonable doubt isn't 100% certain. I think that you can't be afraid to find that level, that standard of proof in order to make the charge. So I think that you just have to make sure that you trust the sources, that you do have evidence, that you listen to what the victim has to say. There are always going to be arguments for why perhaps the accused didn't do what they are accused of, but that's what our justice system is for. It's for the prosecutor to say, have we met that burden of proof, that reasonableness burden to file the charge? And then the jury to decide, now, do we have proof beyond a reasonable doubt in order to find a conviction? Now, along the way, if something happens, if something changes, if a child recants, there are lots of reasons a child might recant. I've had lots of cases where a victim denies what they said. It doesn't mean it didn't happen. And it doesn't mean that I would decide all of a sudden to dismiss a case, quite frankly. I have prosecuted and I've been successful in cases where a victim recanted at one point. I think the issue in those situations is that you have to make sure as a prosecutor that you keep in your mind, it's not about winning. It is about making sure that you protect everyone's rights, including the defendants. They have constitutional rights, and it's my job to disclose if that child starts to waver or falter with me while I am meeting with that child and talking with them. I have a duty to turn that information over. And I think that I know that in lots of cases, if I had any kind of an addition or a change in a statement by a witness, that's something that I put together a report, a statement, and I always submitted to the defense attorney in those situations. And, I do that not just because I have an ethical duty to do that, but because one of the standards I give juries is when you make your decision, you should be able to go home, lay your head down on a pillow and sleep at night. And I have to have that same standard for myself. I would not be able to live with myself if I didn't feel good about what I was doing and how I was doing it.
Very good. I remember a time when and I think a lot of people think this too, is defense attorneys are a special kind of evil. But I had someone that pointed out to me we were watching court TV, and I had made a comment about the defense attorney, and they said that it was not about defending the quote unquote criminal. It was about holding the state to their job.
Right.
And once I changed that perspective, then I started seeing the state's case very differently, because it's like all of a sudden I'm holding them to that same standard.
Right. There's a balance. That's the
Right.
whole, our system is definitely not perfect, but
Right.
we've got this yin and this yang that go against each other. That really makes it about as perfect, I think, as you can get with us as imperfect people. Right.
Right.
Yeah.
Right. Okay. Of course, Henry County's been in the news quite a bit.
Sure.
And I think this one stems more from like the probation office ordeal. If a law enforcement officer brought forward a case that appeared questionable or involved improper conduct, how would you handle it as a prosecutor?
Okay. So first of all, if an officer commits misconduct and we are talking about possible a criminal offense, if it's misconduct, like they drove a car, an agency vehicle that they weren't supposed to drive, of course, I have no jurisdiction over that. That's something that's handled within their agency. If it's something that there's a suggestion of a criminal offense, and it's connected to their law enforcement duties, then what would have to happen is that agency would likely have to ask for an outside investigation. Like, let's say something in one of our local law enforcement agencies, they would probably reach out to the Indiana State Police and say, we need you to come in and investigate this. And then if the Indiana State Police said, oh, yep, we found something, it's not my job to initiate that investigation. It would be like the Indiana State Police Department who would be submitting that investigation to me for review. I think it's always hard to just answer questions about hypotheticals without having, there's so much that can be different. And so I think the two things that I would consider would be, okay, so then I can look at this and the situation, and I can think, okay, do I believe that there's probable cause here to file a charge? If I do, nobody is above the law. And so you have to pursue that case, that situation, just like you would any other case. The thing that can be tricky is that because it's law enforcement, you have to decide, okay, well, also, how is my community going to feel about me deciding whether or not to charge this case? Because they may be fearful, rightfully or not, of some sort of implicit bias, right? Because I do have a partnership with them. And so you have to decide, do I want to consider utilizing a grand jury who would come in that situation and would review evidence and testimony to decide if they find probable cause. In that situation, you might have the community feeling like, okay, yeah, there's less bias. Transparency might get lost along the way because those proceedings may not be allowed to be public to everybody. So you may have no idea why those individuals made the decision that they made. You also have the issue that that's going to be more timely and more costly for our community. Whereas if you go through the prosecutor's office in terms of deciding whether or not to charge, you may have transparency. You may have the prosecutor say, I didn't find probable cause. This is the information I had, and this is why I made my decision. You may not believe, though, in the community that prosecutor was unbiased in making that decision, but you'll get an answer possibly faster, and it may not be as expensive to get to that conclusion. So I think it just depends on what the situation is and what I would feel like was in the best interest of the community as to how I might handle that or what I might do in that sense. And then I would also say that if you have a situation that occurs like that, you're also going to find that it's likely that you're going to have a special prosecutor that comes in to make sure that in pursuing that case, if you're concerned about bias or transparency, that there is somebody else who's actually being zealous in pursuing those charges. Now, if in addition to committing a criminal act, this agency or this law enforcement individual is tied to a case that is either, an investigation that's pending or an active case that's already going forward, then you have to think about, even if the misconduct doesn't rise to the level of criminal, of a criminal act, does whatever that incident was, does it affect your finding of probable cause? Do we need to look now at dismissing this case? Definitely there's going to be an issue where you're going to have to disclose something to the defense attorney about what you've discovered or what has happened. Sometimes the system takes care of itself. Sometimes you have officers who make a mistake. Maybe they forgot to advise an offender of their rights, and they elicited a comment from that, a statement from that offender that they shouldn't have elicited. And maybe, maybe what that officer did isn't criminal. Maybe they didn't even do it with malice intent. Maybe they just made a mistake. And maybe, I don't know what would happen in terms of how their superior might treat them. But you might end up having a suppression hearing where the defense attorney says, look, I think that statement that my client made should be kept out of court now. I don't think it was obtained properly. And then the judge decides. So sometimes the system takes care of itself.
Yeah. And I think bias, and because you, especially in Henry County, I don't know about other counties so much, but I hear good old boys club so often, but I don't see that as being kind of the norm anymore. I think people are realizing that in order to have bias, somebody's had to have done something wrong to put their friend in a very awkward position.
Yeah.
So, why did they put them in that position to begin with?
Yeah. I mean, I want to be transparent myself. I think for the most part, I have a lot of respect for law enforcement and what they do. I do look forward to working with them in a professional way. Again, I think that I still, in the role of prosecutor, need to maintain autonomy. Just like I have no doubt that the officers will call me out if they get ticked with me and something that I do. I mean, they've never had a problem with that in the past. And I have no reason to believe that they'll have a problem with that in the future. But I really do believe that, I think the biggest problem when it comes to misconduct, and the most important thing we can do, is preventative. I think that, again, going back to that communication, I think you're most likely to have problems when you have a disconnect between law enforcement and the prosecutor's office, because then you have officers who don't really know what's going on and they're getting frustrated. And so you're less likely to make well thought out decisions. And so I think that's when you're going to be most likely to have your problem. And then the problem isn't just with law enforcement, it's with the prosecutor's office too. We're all to blame. We're all in it together. So, yeah.
Yeah. Very good. Okay. It was mentioned the other night that there's talk already of a bigger jail. A lot of people say we need swifter justice, not a bigger jail. So if you are elected prosecutor going in, what types of crimes would you prioritize from day one to get things flowing?
Sure. So again, I don't think I can make any promises about anything. However, I do think that there are situations in which it's worth looking into and talking about pretrial home detention in some situations. I remember there was an attorney who served as an interim judge for a while at Dunsmore, and we would have lots of back and forth about this when he was filling in after Judge Witham left in Circuit Court 3. And he was a big proponent of making sure that you don't have individuals who maybe are being held for low-level crimes like misdemeanors or like a level 6 felony just because they can't afford to post bond. And so I think that there are situations in which the jail list should be reviewed and considered. So let's say someone is, being held for a possession of marijuana, and it's something that, they can't afford to post bond. And there isn't an active victim involved in the case. And maybe you have a conversation with community corrections, the judge of the court that case is pending in, and the officers involved in that case. And if everybody unanimously feels that, yes, this is a case that we don't want to just have no accountability, but maybe we should release this individual on, pretrial home detention until, they can have their day in court. That frees up space within the jail, and we're not just holding someone for the mere fact that they can't afford to post bond. I don't feel comfortable making those decisions if there's a victim in the case and the victim themselves are not on board with that decision. And I think it has to be something where multiple agencies are involved in the decision-making process, because inevitably, if we do that, at some point, you're going to have someone with something, a very low level, charge, who is going to mess up. And it's going to be a mistake for everyone. And so you have to make sure that it's not any one person who's being, on the hook for that. But I think that's probably what I would be most likely to look at in terms of trying to deal with crowding issues in the jail. I think that in terms of efficiency, always, that one touch point that I talked about, how quickly does the prosecutor get to looking at the investigative report and deciding, how we're going to move forward with these things and what is the evidence, how quickly are we getting that evidence to defense attorneys. I think that those are good metrics to monitor to keep things moving forward that the prosecutor's office has control over. Unfortunately, we don't have any control over the court schedule. We don't have control over, God love him. I was a public defender once, and you're slammed, just like the prosecutor slammed. We're all slammed with cases. And so you can only get to everyone so fast, and they have to be able to do an effective job for you too. And so there are going to be times when people are going to have to request continuances. But just making sure you're doing your part and trying to keep things moving forward is important. In terms of prioritizing cases, I don't think any one case should be handled or pursued at the detriment of another case. That's one of the beauties of the prosecutor's office, having multiple deputy prosecutors. You don't have to worry. You've got one deputy prosecutor who is specifically overseeing level 6 felonies and some level 5 felonies. So you don't have to worry. Does she also have a level 1 felony rape case that she is, taking care of and trying to balance those needs? I think that, and that's just kind of a different topic. I think for me, a lot of priority is given to cases with victims and higher level felony cases are most likely going to require more attention and more time. But that doesn't mean that level 6 felonies or misdemeanors are any less important. In fact, I've talked with past prosecutors about how sometimes we really miss the days when we worked on infractions and misdemeanors and juvenile cases, because those are the cases where sometimes you feel like you're making the most difference in the community and the biggest impact, because you can actually take someone who is caught driving while suspended on their license and maybe help them figure out, okay, maybe it's just because you're indigent and you don't have the, resources to get that license reinstated. Let's help you get that fixed and turned around so we can get you back out there driving lawfully, and so you can be a productive citizen in our community and feel good about yourself. And so I think those cases are just as important as some of the higher level cases too. So that's kind of a lot. I hope I answered your question.
Yeah, that was actually great. Okay, we've got a lot of candidates in the prosecutor race and in the sheriff's race. So ultimately, we're looking at maybe having a new sheriff and a new prosecutor. In a perfect world, is there anything that you would like to see out of both offices that would change, I guess, change the community's perspective and how things are done now versus under you?
So, again, it just goes back, I think, to open communication. I think respect is important between both the, like where you're talking about the sheriff's department and the prosecutor's office, but, all law enforcement agencies, that respect is important. It doesn't mean that we are always going to agree with each other. I can think of times, when we had disagreements, but you have to be respectful in how you present that information, and you have to acknowledge that the other party is frustrated, but explain why you made the decision you made, even if you don't agree about it. So at least they know why you made that decision. Just talking about it and figuring out how you can take that and build on that for the next situation or case or whatever comes up along the way. But yeah, I just think open communication is so important, and I'm not sure all communication right now is the healthiest between different people.
Right. Okay, one last question. How would those who have worked with you describe your leadership style?
That's interesting. That's something that I haven't asked people. Okay, I guess I will say this. So it's kind of weird campaigning because it feels weird talking about yourself. But one of the biggest compliments that I have gotten here recently was from one of the bailiffs in the courtroom after I had a hearing. And I think this is something that a lot of people have said in one form or another. I wrote a report in a case because I was serving in a different capacity. I was serving as a guardian ad litem in a case, and I wrote like a 25-page report and included hundreds of pages of evidence with this report. And the bailiff, when I was leaving, he said, "Yep, I always know I can count on you to do the research and to do it right the first time around." And I think that's probably what makes me the strongest at what I do in the courtroom even. It's that I think a lot about different scenarios. I prepare the heck out of what I do. Even if I think I know what a statute is or what a law is, I always go back and look it up again to make sure I'm still on point. So I think my leadership style is to make sure that I'm prepared and I make others feel prepared and that they can trust the information that I give them, that I'm not doing something on the fly. When I have cases that involve law enforcement, I make sure that I have gone over their report with them and talked to them about what questions I'm going to be asking them, what questions I think the other attorney might be asking them, so that they can go into that courtroom and feel confident about what's coming up too. I always let people know that it's okay to make mistakes. I don't want people to feel afraid to come to me with mistakes that they've made, because if they're too scared to talk to me about things, then we can't fix those mistakes. And there's very little that you can do that can't be fixed in our profession. The problems arise when you make a mistake and you're afraid to tell anyone, and that mistake then compounds. And so I want to make sure people feel like, yes, you can come to me and you can talk to me about this, and we will come up with a solution. I think that I try very hard also to make the people I work with feel comfortable about being educated and trained with what they do. I always try to work closely with the clerks in our office, and I try to work closely with the paralegal in my office now to make sure she understands what I'm doing and why I'm doing it. It's not just that I'm giving someone a task to do, that they feel confident too. So I try to empower people, I guess is what I would say. That's my leadership style. I try to be open and communicative. I try to be accessible. That's my goal and my hope. And I hope to continue doing that. I hope people know that I listen to all different perspectives. I think I even, to a certain extent, get along with most of the defense attorneys in our community. Sure, we can really go head to head sometimes, over contested issues, but also we'll have good conversations about, hey, what can we do in this case? Maybe this is one that rehabilitation is a good option. What do we think about this? And try to come up with real world solutions too.
Very good. Well, I know the other night you were short on time, so if there was anything that you didn't get said that you would like to say, you can do that now.
Sure. So saying that to a lawyer is tricky business. There's always more that we can talk about. We can say one thing I do think I will just, say it's another thing that sounds strange to keep sharing with people. I am a problem solver. I am a puzzler. I do enjoy that part of this business. I do try to be professional and open-minded and treat people with respect. That doesn't mean that even though all of that comes in this petite package that I can't be tough also. I really like to advocate for good causes and for the people who I care about. I like to advocate for my community. That's another big piece of why I'm doing what I'm doing. I grew up here. I raised my family here. I still believe that community service is so important, and that's why I, volunteer for programs like CASA, the Court Appointed Special Advocate Program. I work as a board member for the Red Tail, Land Trust Conservancy. I think it's important to protect some of the beautiful places in our community. I like helping with the CIT program that helps our law enforcement, recognize mental health problems. So I really like the community side and that service. And this is just another way for me to serve my community. But also I can get tough sentences. I can take cases to trial. I did have a successful, level 1 felony rape case that I took to a jury trial for a 66-year sentence. And I did have a child molest case that I took to jury trial, and I was able to achieve a 20-year sentence. That's not to say I'm never going to lose a trial. My first jury trial I was unsuccessful at, but it didn't stop me from going out there and doing it. And even though I was unsuccessful in one case, it didn't stop me from doing it again. So I just want people to know that if elected, I will be conscientious. I will be compassionate because I care about people, but I will also be fearless.
Very good. Very good. Well, I really appreciate you taking the time to do this.
Thanks.
I'm hoping I just came up with the idea one day on a whim, and I think it's a good way to reach a much broader group of local voters.
Yeah.
I know my dad would never go to the forums or the meet and greets or anything like that, but he will click a YouTube link.
Yeah. Nice.
So
Well, yeah.
I'm really looking forward to seeing how this goes, and if it goes well, then maybe we can make it a regular thing.
Yeah, thanks for the opportunity. I really
Yeah.
appreciate it. Just like, everybody has different learning styles, the same thing. We all have different ways of approaching our political process. And, you talk about, accountability. The biggest way that we can provide oversight, I think, for any of these offices is to get out there and vote. And so find those people, do your research, and decide who you trust and
Yes.
get out there and vote. So thanks for giving us the opportunity to talk.
Well, thank you. And I hope you have a great rest of your day and have a wonderful Easter.
You too. Thank you, Gayla.
Thank you. Take care.
You too.
Bye. Watch or read, they have both options.
Gotcha. That reading would be a task, but I guess maybe somebody's on an airplane somewhere and they don't have their headphones.
True. Okay. Well, I appreciate you taking time out of a very busy weekend, I'm sure.
Thank you. Thank you for fitting me, and I appreciate it as well.
And I think this is going to be a good thing, because I think I'm hoping that it reaches a much broader audience, because everybody can click a YouTube link.
Correct.
So
I'm just
okay.
doing a couple of odds and ends on positioning on my side, so
Okay.
sorry.
You're fine.
Uh-oh, that's not what I wanted to do. Sorry, I apologize.
You're fine.
I'm trying to get it so I can see you bigger, and this is the fun part for everybody. Sorry, whoever gets to watch this later on.
Yeah.
No, that's good. There we go. I got it. All right. Thanks, Kayla.
Okay. Good deal. Okay. If you want to take just a second to introduce yourself.
I am Kyle Allen. I am not an IT guy, as you are well aware now after that opening there. I'm a Knightstown resident, and I am running for prosecutor. Michelle and I moved back here to Knightstown. I guess it's been 6 years ago now, and she grew up here. We've got our family here. We're raising our kids here, and we get to run around and let them run around outside like we did when we were youngsters as well. So there's a brief opening for you, a little bit about me.
Awesome. Okay, first question. What do you believe is the most important responsibility of the prosecutor?
I think the most important responsibility is community leadership. It's about more than just being in the case and processing cases. I think the prosecutor's office and the role of the prosecutor is to be an individual that is visible in the public. So people know that as far as law enforcement goes in the county, there is you've got your officers. Everybody thinks about officers, but after the stage on the streets and arrest, I think people also need to know what the office is doing. And there needs to be communication from the prosecutor to the community to say, this is what we're doing. And these are our community initiatives. These are our law enforcement initiatives. These are the things that we are doing so that this community where we all live is getting healthier. It's getting better. It's getting safer. but also I think part of that is the casework. The role there and the duty there is to make sure we're taking care of the cases that move through and the people that are involved in them the best way possible. So from a prosecutor standpoint, it's more than just the case. It's also, community leadership, but that takes understanding where you fit in the big picture of the county government as a whole. I think that the prosecutor needs to be very active and involved with, like I said, law enforcement initiatives, but understanding that if down the road we want to have a community where we want our children to stay and remain and thrive, that starts now with initiatives that we start right now, as far as how do we make the streets clean? How do we make this a place where families want to grow and businesses want to grow as well, so that we have a community where people want to relocate to and add to our tax base, so we can start getting all the call them the fringe things that communities want, all the bike trails, additional housing. The office fits into a much bigger scheme than just the criminal justice system, because what it does is it touches the whole community, Gayla, in my opinion.
Very good. I like that.
Thank you.
I do like that perspective. Okay. This is about you and your vision. What would success look like for the prosecutor's office under your leadership, including the effectiveness of the attorneys, the office staff, and the support team? And how would the public know that it is working?
So one of the successes, we'll call this the inner office success. One of the successes that I would really like to see, and one of my goals, is to take what we've got from a caseload and work with not only all the people in the office, but all the people and officers, everybody in the court system, to know exactly how and when other processes come to our office. And then once things are in our office, make a defined, I called it a railroad track the other day. This is a railroad track. And if anything's going to deviate from it, it's deviating because there's already a switch there and we know it's going to deviate for certain reasons. So I think any organization has to have a dedicated system and a process in place just for information management, case management, because when you have a system in place with defined roles and defined checkpoints along the way, you're going to have expectations for everybody. And those expectations lead to accountability. And when everybody is working on that same dedicated railroad track, we're all in that same lane, and we know where things not only need to go, where they're coming from. When everybody understands that, then we're going to be much more efficient. And when we're more efficient within the office, what that does is that allows us to spend more dedicated time working on the more important issues within cases versus the ministerial task-oriented things and tracking things down here and there that I feel like I'm experiencing right now. Being there for 4 months now, there's still a lot that I see or don't understand from a process standpoint. And I'm starting to realize that some of that may be because there's not a well-defined process for that yet. So mapping the entire office within and how it's connected to other agencies outside, knowing how every single piece moves in and out and through the office. When we get that process, that's one of the first things I'll start building as prosecutor, or if elected in the primary, working on and focusing on through the rest of the year, is making sure we can get that railroad track, that foundation is laid, so that we can then focus on the other bigger things that we need as well. Because if we've got more efficiency, we can also then utilize the people we've got to their fullest, but then we can really start focusing on where do we then get the specified funding for exactly what we need to hire in our office additionally to help with our caseload. And one of those big pieces is a victim advocate. So having a foundation, that railroad track laid, knowing that we all need to be we need to be much more efficient. And then knowing that we're also going to be looking at having another individual in the office to help work with victims specifically. That's one of the first things that I want to do. And one of the first things that is very important. So that'll be one gauge for true success. I think aside from that, looking outside of the office, my next success thing that I think about is having well-defined collaborative goals with all of our law enforcement agencies across the county, saying, all right, guys, if we can all put our heads together and decide A, B, and C are the most important things in a prioritized list, from that list, then we can then work on what the crime reduction initiatives to target those things are. So if we have that in place with the brass, as they say, the leaders of local law enforcement, having that in place then allows us to, part of that would be setting checkpoints or data metrics to see, how arrests and whatever plan A was, arrests that are associated with that, how many of those have been productive in meeting what those goals actually are, so that we can start measuring some of that data. Because again, I think if we have those goals laid out, then we can start seeing if what we're doing is working or not working, and start to have just more effective, connected crime fighting across the county. I think that would be, having everybody geared in the same direction, I think is very important. So that being able to measure that would be a success in my opinion. And then another success would be more on a from a public relations standpoint, having dedicated community engagement events where we can have folks come in, not to the office necessarily, but at a big place where we can all meet and do like a community training on how do we make our own homes safer? What are simple things that we can do from a crime reduction standpoint, a community-based standpoint, like talking over how officers like to work with community members with their Ring cameras, and where does it make sense to have bushes trimmed back here and there? Just because there's so much technology these days, and that's just a little piece of that example. But if we have some of these events planned where community members could come out and be engaged in that process and learn and know how they can also help in simple ways like that, I think that would be a huge success for our office as well. And then also publishing our victories that we have. When good things occur, I think the community really needs to know about it, and we need to champion the good things that we do, because as we know, the only things that we usually hear about, and from a news perspective, are the negative things. So the community needs to know what we're doing and what we're doing well also. So that's really important. That's one of the things that, at the end of year one, if we've had 3 community events and we've established a solid, public relations, not maybe just new avenues through an updated web page, just so people have the ability to engage with us a lot more. I think that would be a huge victory for us too.
Green. Okay. Voters want to know that true child predators are prosecuted aggressively while also ensuring innocent people are not destroyed by false allegations. How would you balance victim protection, evidence standards, plea negotiations, and due process?
Well, first, the second a case comes into the office, we have to take a look and diagnose what type of a case it is. And is this specifically in regards to violent child predators, or anything that involves children from a crime standpoint? I guess that's a clarifying question, Gayla. We just talk I'm thinking like child porn, child abuse, anything in those realms, child molestation, any of those type things. I feel like those are all obviously extremely harmful and the worst of the worst, because obviously my kids are 3 and 7, and my biggest thing is if we can protect our children, then we have a future that's going to be a heck of a lot better, no matter what, if that's one of our collective goals. But diagnosing cases when they come in and knowing exactly what the nature of the crime is, obviously that's part of what we do, but seeing, is it a case that actually involved a real child? That's something that we have to weigh. Because of AI these days and things that can be done, our laws have changed to say the children don't need to be real identified children that we know for different types of child sex abuse material to be considered a criminal act by, the possession of it, the creation, the distribution, whatever. We got to look and see where in that totem pole the that material falls. As far as and just gauging the nature of the offense, if it actually hurts a child, we've got that spectrum. It's hard to put it that way, but the priority would be on any of those crimes. But within that, you still have to prioritize which of those are the worst of the worst. And those that are the worst of the worst, where you have an actual human being that you've had the unfortunate circumstance of being around or laying eyes on and seeing the nature of the abuse or the crime that was committed and how it's impacted them. That's where our focus is going to be, on the stiffest penalties possible. There were, I think, 4 parts to the question. Gayla, can you help me with read through it again? Because I want to make sure I answer all of them.
How would you balance the victim protection, the evidence standards, the plea negotiations, and the due process?
Okay. So the evidence standards, I think what I was just speaking to was a lot about what is the evidence, what's the nature of the crime. Those are very much related there. But as far as due process goes, defendants have rights constitutionally guaranteed, but people have to remember that under Indiana law, victims have rights too. So we need to make sure that we're standing up for the victims in any of these types of cases. And again, that's where we're talking about having additional support from a victim advocate is really necessary. Plea negotiations, every case, while all crimes fall into various categories and they are charged the same within those categories, there's only so many crimes that exist. Every single case is different. You never know if the victim of one crime and their family are going to have the same moral, ethical, religious views on how punishment should be meted out. So that's something you have to always take into consideration from a plea negotiation standpoint. And I think everything related to plea negotiation needs to be thought of from the standpoint of what makes the most sense for the specific case that you're working on, based on who the victims are and what they actually want. So plea agreements, when they do occur, remember, like 99% of cases are resolved with plea agreements, basically speaking. In the criminal world, plea agreements are the settlements that occur in the civil litigation world, where they settled out of court. That's just the nature of our criminal justice system and our legal system in America. It's not, I mean, every system does have flaws, but I think we've got the best one in the world. So we can't take every case to trial. Some cases will require trials, and that's perfectly fine. Also, when it comes to pleas, again, the nature of the crime and who's involved, and the risk of a case being close on an issue or two from an evidentiary standpoint, that's where a lot of times victims may feel, and often do feel better. Maybe not initially, but after they've had time to process, or victims' families even. I was just talking to somebody yesterday about an event that happened with their mother and how they felt. It was a crash years ago. Anyway, but how they originally reacted to it and how things changed over time. Knowing that the plea agreement that is going to put the person in jail for 10 years or whatever is a guarantee on that person going to prison for 10 years versus the risk of a juror. Just, you never know what juries are going to do. They're unpredictable in some situations. So that peace of mind is a lot of times a big factor as well that comes into it. I mean, our job is to communicate what all the pros, the cons, what they are in a case, and what the outcome might be if we go one way or we go another. So again, that all involves communication with the victims and the families, the people that have to be part of that conversation, to know exactly what the right thing to do is. And like I said, some cases, the only way to resolve them is trial. And when that's the case, that's what we do. That's what we need to do. Yeah, evidentiary things. One of the biggest issues from an evidentiary standpoint that I see, and I think is always going to be the case, is especially dealing with children, is the age of the child. What can they remember? What can they communicate? And what is unfortunately, what's the believability? Because even though I believe, if I've charged the case, I believe that the offense occurred, sometimes it's really hard to know how things might be interpreted by a juror. And again, sometimes we have to protect the victim even more from what could be an awful day reliving things in court. Those are all, again, factors we have to weigh. And then evidentiary reasons, how strong is the case based on memories of often a really young child. So it's awful that that's the case, and we have to think about that as a factor, but oftentimes it does come up. So we have to approach those very, very carefully when we make those decisions.
Okay, since you were given so little time the other night,
Oh,
I mean, I was sitting in the crowd, and I would hear that dinger, and I would panic, just trying to hurry up through your guys' answers.
I think the inadvertent being very first, I don't know if it was just a malfunction or a phone call or something that came like halfway through when I was going, and by the time
Right.
that got turned off, is like my time was up. And anyway, it's all good.
Yeah. Yeah. So since you were cut short, please give some detail, your specific experience that prepares you to serve as prosecutor for Henry County.
Well, I've been doing it now for 4 months, which doesn't sound like a long time. And it's not, but it's given me the ability to learn to relearn a lot of what's still up top in the brain from a criminal law standpoint, and just start knocking that dust off, or rust off, if you will. My first 5 years, I practiced nothing but criminal law as a lawyer, and then moved away from it because I was doing I was on the defense side, and all through law school, all I wanted to be ever was a prosecutor. That never occurred early on, other than being able to volunteer for several months after passing the bar back in 2008 at the Hancock County Prosecutor's Office. So the job market was a real bear back then in 2008, after just in the midst of the financial crisis. So I did volunteer work, just trying to learn and get my foot in the door somewhere. And then ultimately the Marion County Public Defenders, where I started my criminal law practice. And then from there, I did it privately for 4 years after being at the public defender. But the life is funny, and it could be a roller coaster at times, and I think everybody can agree with that, especially when it comes to your goals and your dreams. You never know if some of those dreams are if they're gonna come around, or when those things might happen. But this just all happened in such an odd way and came together in such an odd way, but a great way, that I'm very thankful for the opportunity, knowing that, the chief deputy, Rick Franke, and I were law school friends. He and I worked across from one another in Marion County for several years. And then knowing that there was going to be a retirement in our office at the Henry County prosecutor's office, Rick and I were just having lunch one day, and he said, "You think you'd ever come and work as a prosecutor again?" And I said, I was just having a conversation the other day with another law school buddy, and I said, he asked me, "What else do you want to do in your career?" I said, "Well, other than retire, I want to do prosecutor work." And I shared that with Rick, and we really started. I really started to think about it, and then I started having the "Hey, Michelle" discussion. I've been considering this, and then once she was on board with making a big career switch away from being in control of my own private practice and all my hours, the kids are grown up enough. Brooks is in preschool. All those things in life were moving in the right direction at the right pace. We were in the right part of our lives where this potential, new job, career shift, it was a possibility. So, some people say all things happen for a reason or whatever. I don't know if I believe that, but it makes you stop and wonder and put your foot on the brake pedal for a second and go, this is really interesting how all of this came together at a time where it was possible. And I'm very thankful for that. And then from there, the discussion became, when we knew that Michael wasn't going to run for prosecutor, then at that point, I decided, yes, I will run for prosecutor. But that's the background. And you talk about a whirlwind, because at the same time as closing down practice, starting at the prosecutor's office, we just moved into a new house a couple of weeks before Christmas. We were building that. So all these things were going on. Then every single prosecutor's office is different because they have their own office environment culture, even though at the end of the day, your prosecutors' offices are doing the same thing. So you're also learning a new job, a new role. So it's been a whirlwind. And then you throw the campaign on top of that. How could I forget that aspect? So life has been a whirlwind since December. But again, I'm learning a lot, and I love learning, and I don't like being stagnant. So even though there are days where I'm extremely worn out, I know I'm doing everything for the right reason, and coming home and seeing the kids is a constant reminder of that.
Right. I'm a big believer in everything happens for a reason, serendipity. And if you don't listen to God's little hints of trying to nudge you where you need to go, he's going to put a huge roadblock in your way, and he's going to knock you on your butt until you figure it out. So I learned to listen to the small hints.
Good thing I had my ears wide open, I guess. I'm very happy with the decisions that I've made. I think I need to say that piece as well.
Yeah.
And
Very
I'm
good.
very hopeful for the future too.
Very good. We do have there, of course, Henry County's been in the news a lot. If a law enforcement officer brought forward a case that appeared questionable or involved improper conduct, how would you handle that as a prosecutor?
So I'm going to separate those. If it didn't feel proper, or questionable, I think was the word, that's where we say, look, I understand the report, and at this point, there's probably it's either an arrest or they're requesting a warrant for an arrest. Here are the problems that are involved in this case, and that's a conversation that does happen. Or if you want to file this case, this is the additional information that we need. So again, we're looking at probable cause. Did we get there the right way to make this actual arrest? So if the evidence is questionable, or if there are major legal hurdles from a suppression standpoint, by suppression standpoint, I mean, defense counsel is going to go, oh, officer, you didn't have the reasonable suspicion to even make the stop or whatever. We're always looking at cases to see what questionable legal issues exist. And then it's always, if there is a questionable legal issue, it's the discussion, training, the learning, us sharing. We need these dots connected, or A, B, and C also in here for this to be not questionable, but solid now. If something happens in the other arena where it's questionable or it's obviously improper, then that's a whole different can of worms. If something's done for an improper reason, then you come up with any hypothetical, but yeah, at that point in time, that's where we need to take a look. And in the prosecutor's office, I would say, okay, what are the ramifications of this? Is this the ramifications of potentially, is this a disciplinary thing that needs to be handled by the law enforcement agency itself? Like, where are we on the spectrum of improperness? If it's something minor, like related to a traffic offense, oh yeah, that was my buddy, so I let him go from the stop, or she gave me her phone number, so I let her go. Make up anything there. That's really small on the list, and that's where that person's supervisor, that officer supervisor, needs to be involved in that and say, you can't be pulling that stuff. That's improper. That's you're better than that. That impacts all of us so much more than you may have ever thought of in that situation. I don't see that right now. So it's not occurring right now, thankfully, but that is something that I think would need to be addressed immediately with that law enforcement agency. Say, we're aware that this is occurring or has occurred. But if it's something more major, then as prosecutor, that's where, if it's bad enough, that's where I think we need to alert state police and have them aware of the occurrence, so that there can be an investigation done into the matter from an outside source that's not within that agency itself. Just so, the old word transparency, so that somebody else is doing it and managing it, so that no matter what, we know we have made the right decision and informed somebody that this has occurred, so that the right result, the right outcome is done from an independent third party. And then if there is a recommendation from that outside law enforcement agency conducting that investigation, if there's a recommendation for a prosecution from that, then that's likely where we would need to have and ask for a special prosecutor to be involved to handle that type of a case. So again, we're avoiding any conflict there that I think would inherently exist.
Okay. Very good. I think a lot of that stems, because I did get a lot of these question ideas from the community.
Mhm.
And I think a lot of that stems from the case with the probation office. And it seems like there were numerous instances that were reported, but appearances were that it was swept under the rug and that it wasn't being handled.
Mhm.
And I think the community just wants to know, when something like that happens, that they're aware that it's not being swept under the rug. It is being handled. It is being investigated. You know, it's just a lot of times the wheels go slow.
Yeah, those wheels can move slowly. That's for
Right.
sure. You know, one of the things I do pride myself on, and I think it's important, is that sure, I've been here for 6 years, but I don't go back 30 years with people, and I don't have favors that I owe anybody, and nobody owes me any favors. There, you know, that doesn't exist. So when I say, you know, it's a facts and law game, I feel confident knowing that that's what I can focus on. I don't have to worry about who knows who or what happened or favors or anything. I don't have any favorites to play other than being the champion of, you know, the people that are victims of crimes coming through the office. Those are my favorites to take care of them, essentially. And then hopefully that's never a case that comes up, but it's always a possibility. But my opinion is that, you know, that's where it's a hands-off deal from the county perspective. We need an independent third party involved.
I think that might have happened in the old days, but you know,
Mhm.
more so than now. But
And back when I was on county council, there was chatter back and forth about all those things back in the old days. And you know, a lot of our officers are younger these days as well. From
right,
the sheriff's department at Newcastle, even out in the towns. So I don't feel like there's as much of a connection to the past, but and I think that that's a positive thing. I think for the county to
it
go
is.
forward, a connection, everybody being connected to the past is not a good thing for Henry County going forward. And again,
Right.
that's why, you know, I believe I offer that disconnection from any of that past stuff, which is good going forward for us.
Right. And what a lot of people don't realize is that if you have, you know, this person that's breaking rules, breaking laws, committing crimes,
Mhm.
it's not a matter of whether the law enforcement officer is connected or not. That person that broke the laws and broke the crimes put their friend or their connection in a
Mhm.
bad spot to have to deal with them.
Mhm.
You know, it's not a matter, you know, so I think a lot of people are seeing that. A lot of people do, you know, the professionals, the prosecutors, the law enforcement, I think they do handle it that way, as to not so much as, you know, oh, they're my friend, I'm going to cut them some slack or whatever. No, they see it now as they put me in this spot.
Mhm.
I'm going to
Yeah.
do my job.
Yeah.
So
And how dare you put me in that spot?
exactly.
Yeah.
Exactly. Um, I learned a lot of that from parenting, actually.
We all learn a lot from parenting. That's
Yes, we do.
100% for sure.
Yes, we do. Makes us a whole lot smarter, doesn't it?
We'll say yes.
Yeah.
It makes us more well-rounded too. And I think it makes us appreciate a lot of different things in life and in different ways. You know, there's no way that I would appreciate where I am today without having my kids and thinking about them and like looking at them, and I want to make them proud. You know what I mean? I want to do something that's also not only just meaningful for me, but meaningful for them as well, you know, and what I'm doing right now, I feel like that. And it's something that they can understand, and they want to know, uh, Daddy, do you have any fun policeman stories today? That's one of the questions they'll ask me, because they don't understand the full concept of the justice system yet and the role of prosecutor. We're working on it, but I tell them that I get to work with a lot of really good officers, and I get to hear a lot of fun police stories, and you know, some of them I can share, you know, basic information about something, you know, something that's occurred, or you know, like somebody got arrested for doing something silly or whatever it is. We get to share some little stories here and there.
Yeah.
That's what they
Well,
want.
my baby's just turned 33, and that doesn't go away. I'm still trying hard to make them proud. So You never outgrow that.
Of course, any story I share is completely anonymous, and it doesn't relate to any individual and any namesake
Oh,
or anything
absolutely.
like that. But they want to know, did somebody get taken to jail today, Daddy? That's like a big question that they have right now. Like, somebody had to go to jail today. Yep, they did. Interesting.
Mine asked me that, and it's no, I didn't go to jail today. I think they're afraid they're going to have to bail me out one day. Okay. Speaking of jail, I have heard it said in, a few, and I even heard it mentioned the other night that there has been some talk of needing a bigger jail already. And a lot of people think that we just need swifter justice. So if you are elected as prosecutor, how will you prioritize cases that are, I guess, just kind of hanging out there to expedite so that we don't need a bigger jail, because taxpayers really don't want that.
Oh no, and I remember back on being on county council when there was a discussion or a presentation that may have been made about the potential for, I think they were calling it like Pod 2, and I was like scratching my head going, no, that doesn't make sense. We just built one, and we have ways to control who is in there through various, especially when it comes to drug offenders, looking at the drug offenders that are in there, what different treatment options are available, or who needs something other than incarceration for their offense. A lot of our cases, I'd say 80%, I think, are drug cases or drug related cases. And, that's our biggest problem in the community these days, are those drug offenses. So that's where we need to have, a more thorough screening system for those that might be eligible for drug court or different placements. And that needs to be set up and done ASAP. So you can have, the second that somebody's arrested, I think that we need to have like a just like nature of offense, background, where you're from, all those things. There's a bond matrix that says what your bond should be. I think that in the office, we should also develop our own matrix to say this individual's immediately, a candidate worth exploring for admittance into one of our problem solving type courts. I think that would be a good way to move about it. And I do know that occasionally we'll go through the jail list. We get a jail list published to us every day from the jail, and we'll often look at it just to take a look and see, are there individuals in there on a misdemeanor charge for that aren't being held out of another county or something like that. What's the nature of that, of why they're there, or like a level 6 felony, possession of this or that type case. Looking at those type cases and saying, all right, what can we do about these specific ones to free up 5 or 10 spots, and who needs to get treatment? Well, those are things that we absolutely have to have a better process for. But also, I think that tying it back to having initiatives put together with the prosecutor's office and law enforcement on what we want to target and what we want to do from a crime reduction standpoint, I think that'll also help keep numbers down. So there are some times where it makes sense for officers to arrest and take someone into custody, and then there are times where it doesn't. And a lot of that's the nature of the crime. But if it's a small level drug offense, maybe there are other options that can be explored. And I don't know what those exactly are yet or what they look like. But if somebody has a syringe, paraphernalia type case, thankfully, unless they got a bunch of drugs, I don't think they need to go to jail for a syringe or a driving offense, those types of things. Drunk driving is totally different than driving without a license or driving on a suspended license. I think a lot of those folks are in and out pretty quickly if they are taken into custody, but still, if there are 10 people arrested every day for that and taken to custody, that's 10 beds that are full. So those are just type things that we need to look at in prioritizing who goes to jail and who doesn't. Again, if there was a rule, you're going to have exceptions to any of your rules for good reason as well. So those are things that I think would be very wise and reasonable to develop with the law enforcement leaders on, who are we taking to jail and who are we not taking to jail. And I know some of that already exists, but something that we need to refine too.
To me, I look at it as if you need to add on to the jail, then you have failed as a community.
Mm-hmm.
And it all goes hand in hand, better jobs, lower crime, more opportunities, more resources. So
And in the back of my mind, philosophically, if we focus on taking care of our children, there are so many different types of crimes that touch our children or impact them. And not just crimes, but making sure they're in school and having accountability for kids not being in school, that can apply to parents in certain circumstances. Yeah. Looking at it from the standpoint of taking care of the kids, that involves a whole variety of criminal activity, drugs, you name it. If we can focus on them, what's best for them, a generation from now, if we can continue in that path, even before then, we've got to reverse the trend that started back in, don't quote me on it, but let's say the early 80s, late 70s, when industry was leaving Newcastle. That's when the evolution of the types of crimes and escalation and the trend started to develop to where we are now. We've got to stop that and focus on now the future. And I think the way to do that is focusing on whatever we can to keep our children the safest, because then I think the trend will then allow us to grow in the other way, where we've got the future where people want to relocate here and we want to build the tax base back up. Or it allows us to have those fringe things that we want in our community to where it's attractive.
Right.
You're clean. Absolutely.
I think that's one thing that people are going to take away from this video interview process is how all the different departments and processes all kind of work together hand in hand.
Mm-hmm.
No department is an island in and to itself. Everything does work together.
It does work together, and it works together, and it can also, in the same fashion as it works together, it can hinder and negatively impact. One department can, all the others, especially when you look at from the funding aspect of the county as a whole. So that's one of the things that we also have to keep in mind. The things that we all want in the future, we need to make sure that from a funding standpoint, we can attain that. And the way we attain that is, responsibility fiscally, but also good training and good responsibility for the people that are in the highest, the roles that have the highest potential liabilities connected with those roles.
Right. Well, that's all the questions I have. And so now I'll just hand it over to you. And if there was anything that you would have liked to have covered the other night at the forum, but was unable to, feel free.
I got to touch on a lot of that throughout the conversation today. And again, I think when I lost my train of thought, that's when I was going to jump right back into, for being out of time completely, the fact that, the most important thing is focusing on our children, but then focusing on them with a goal and a plan in mind on how we get the things we want in the future and what are the initiatives that make sense to reach those goals. And that was the biggest piece of what I really wanted to convey there and didn't have the opportunity to. So thank you for that opportunity. Thank you for this whole opportunity to chat today. It just so happened it started pouring rain like right after we got on here. So it worked out perfectly from that standpoint too. But
It
Can't believe
did.
can't believe tomorrow's Easter, I think.
Yeah.
And the election's a month away and things are flying by, but hey, to the extent that I get a little worn out from time to time, I'm very much enjoying things and having a good time with everybody as well. So Gayla, thanks again for the opportunity today.
Thank you, Kyle. And I hope you and your family have a wonderful Easter. And I'll, once I get these things wrapped up, I will send you the link.
Okay.
It'll probably be Sunday evening or Monday morning.
All righty.
And hopefully people will take advantage of this opportunity to hear from all of you guys directly.
I know I'll be doing a lot of listening, that's for sure.
Yeah.
You put the time in to do all of this. I think a lot of people will pay attention, and I think that's really positive. I think the more people know and the more people pay attention to our local elections, the better we're going to be as a community. And shameless plug, vote for me.
Yep. Very good. Thank you, Kyle. You have a good rest of your day.
Thank you, Gayla. Bye-bye.
Bye. Okay, we're transcribing and recording now.
Okay.
So, okay, if you want to just briefly introduce yourself to start off, and then we'll go right into the questions.
My name's Cathy. I'm currently the Henry County Chief Public Defender and have been in that appointed position for over 10 years now. I am running for Henry County Prosecutor.
Okay. First question is, what do you believe is the most important responsibility of the prosecutor?
There's several important responsibilities. One of the most is assessing the cases that come before the prosecutor's office. You have to evaluate them and determine their strengths and weaknesses to file the proper charges and take those cases to trial that need to be tried.
Okay. Okay, this is about your vision, okay? Not what is or what has been, but what would success look like for the prosecutor's office under your leadership, including the effectiveness of the attorneys, office staff, and support team, and how would the public know that it's working?
Number one, there needs to be good communication with law enforcement officers. And I know that sounds like a simple statement, but it's more intricate than that. There needs to be open communication where law enforcement knows that they have accessibility to the deputy prosecutors and the elected prosecutor whenever they need it. They need to know that if they have questions during a traffic stop, during an investigation, that they are able to pick up the phone and call a deputy prosecutor or myself, the prosecutor, at any point in time. Crime does not have office hours. And I have told law enforcement officers that I have met that they will be able to call me anytime they need to. Number one, I usually go to sleep about 1:30 in the morning and wake up at 5 a.m. They are free to call me any time of the day or night that they want. And I want them to have the same accessibility to the deputy prosecutors if they need it. I do not believe that's being done now. I actually recently heard that there is one police department in this county that has been instructed not to contact the prosecutor's office with questions. That should never happen. The prosecutor is the chief law enforcement officer of the county, and all of the law enforcement officers need to have accessibility to talk to the prosecutor and the deputy prosecutors in that office anytime that they feel like they need to. So we need to work better on that. There also needs to be good communication with Department of Child Services. There is none at this moment. There are cases that are not being prosecuted that have to do with child neglect and child abuse. I know one case in particular took about 1.5 years to actually have charges filed. And it was actually one of my lawyers in the public defender office that kept pushing to have charges filed. It was a badly battered 2-year-old boy, and I have no idea why it took a year and a half to file those charges. That should have happened much sooner than it did. The perpetrator in that case went off and was dating another lady that had children at the time. That should not happen. So communication is very key, not just with law enforcement officers, but with the Department of Child Services. There also needs to be good communication within the prosecutor's office themselves, and I don't think that's happening at this time. I'm the chief public defender of the Henry County and have an office and manage several attorneys myself at this time. We have excellent communication. We work together, we help each other out, we help each other out on cases. I think that can be carried forward in the prosecutor's office in a positive manner. One of the biggest problems is discovery. Discovery is not being sent to defense attorneys in a timely manner. And I've been very frustrated about this, and I think I have finally started to figure out maybe why that is happening. When the discovery comes in, and discovery, for those that don't know, is the evidence in the case. Those could be DNA results, drug test results, body cam footage, dash cam footage. I don't believe that that's actually going to the prosecutors assigned to the cases. I think it's coming in to the investigator or possibly the clerical staff in the office. So I think that that may be the reason that that discovery is not being tendered over to defense attorneys fast enough, because the prosecutors themselves don't know that they even have it. I had a particular incident recently. The deputy prosecutor assigned to a case I was working on knew I had been waiting on the DNA test results on a particular case, and at some point in time received those test results and gave it to co-defendant's counsel, but did not give it to me. I actually got the discovery on my case from Joe Burgess, who is the co-defendant's attorney. I should not be receiving discovery from co-defendant's counsel. I should be receiving it from the prosecutor's office. I'm beginning to question whether they even view the videos that they get, if they even know that they have them, because we've had several conversations in my office that if they actually looked at the dash cam footage or the body cam footage, they might begin to question whether or not they even would have filed charges or would have filed charges differently. So I think this evidence is coming into the prosecutor's office, but is not actually being monitored by the prosecutors themselves. That's a big problem. There's something that we used to do in Marion County called trial prep. We were required to trial prep our cases soon after they were assigned to us. We had to list out all the witnesses that were necessary for the case, look at all the discovery that was necessary, gather all of that discovery. We had a very lengthy process that we had to go through to prepare that case for trial. And that is getting the discovery in and the information, and then being able to disperse it in a timely manner to the defense attorneys. It's important to try to move these cases swiftly through the criminal justice system. Victims have a right to be heard. They have a right to be heard as soon as possible, not 2 or 3 years after the case was initially filed. Again, I've talked about before, we need to move the cases swiftly so that people don't linger in the Henry County Jail at taxpayers' expense for 2 or more years. It costs $42 per day to house a typical Henry County inmate. The taxpayers pay that bill. If people are sitting in the jail for 2 years while we're waiting to get discovery, that shouldn't happen. This process can be expedited, and we can move the criminal justice system in Henry County much swifter and decrease tax paying dollars. So those are the most important things that I think need to be done, as well as, to my knowledge, we have not had one single dealing drugs resulting in an overdose death, even though our neighboring counties have many, many of those cases filed all the time. I don't believe we've ever filed one here in Henry County. I've talked to the coroner in our county who informed me that we have 13 to 15 overdose deaths per year but yet never held anybody responsible for any of those. That's a shame. That shouldn't happen. So
I have a friend in Hancock County that's awaiting the trial of the dealer
yes,
that cost her son's life.
right.
So, yeah. Yeah, that's tough.
And yet, for some reason, there's not been one single one filed in this county. And it's not because we don't have overdose deaths.
Yeah.
So,
Yeah. Okay. Voters want to know that true child predators are prosecuted aggressively while also ensuring innocent people are not destroyed by false allegations. How would you balance victim protection and due process?
again, that comes with evaluating your case. You have to evaluate the case and determine its strengths and weaknesses. You certainly don't want to proceed forward on a false allegation if you have information that leads you to believe that it might be a false allegation. There's a process involved in trying to determine the strengths and weaknesses of your cases and to proceed forward if necessary. Child predator cases are obviously seen as the most heinous. Something I do want to point out, because I've seen it on social media recently, I, as the chief public defender, for the past 10 years have been defending criminal defendants in the county. And I think some people misunderstand. Yes, I'm running for prosecutor because I think I'd be a damn good prosecutor in this county and I would fight for those victims. But currently, my job and my responsibility, my legal ethics is to my client at this time, which is the criminal defendant. And I think that some citizens don't understand that I have to still ask what is suited within the parameters of the sentencings for my clients. I had a recent trial, and I think I've seen some things in social media where people were upset with what I was requesting for a sentence. I think people need to understand that that's my job as the attorney defending that individual. That does not mean that when I become the prosecutor, I would be defending the state of Indiana and its interests and the citizens of Henry County. My requests obviously would look very different. So I would definitely be asking for executed sentences for people convicted of sex crimes, whether it's against children or adults.
I had someone put it to me recently, because there are a lot of people who think that defense attorneys are a special kind of evil. Well, once, and I used to be one of those, but once it was put to me that a defense attorney is not necessarily defending the criminal because they believe in the criminal.
Right.
They are
defending the United
ensuring that the
States
state
Constitution.
presented right. And once it was put to me that way,
Right.
I tend to look at the state's case through a harsher lens than the defense.
Right. I'm
So-
defending everyone's rights, not just a person that's charged.
Right.
The average citizen doesn't want to be stopped illegally or have their car searched illegally. I'm defending everyone's rights in trying to prevent those illegal searches, seizures, charges being filed against somebody that are false. And that's the job as a defense attorney. And I do think some people lose sight of that. So,
Yeah. Yeah. And it's easy to do.
Right.
But it's one of those things that once you see it, you don't unsee it.
Right.
Now, once you see how the process really is, you just don't unsee it.
Right. And something
So-
I'd like to point out, Joe Burgess was the elected prosecutor for, I believe, 12 or close to 12 years. He now works for me in the public defender's office. people think that you're not able to see both sides of that criminal justice fence. And yes, you can.
Yeah. Yes, very much so. Okay. Give some, I know the other night that the forum was very short on time.
Yes.
So, go into specific detail of your experience that prepares you to serve as the prosecutor for Henry County.
I am by far the most experienced candidate. Again, I've been appointed as the chief public defender for over 10 years here in Henry County. Prior to that, I was both a deputy prosecutor and a deputy public defender in Marion County for 14 and a half years. So I was admitted to the bar June 1 of 2001. So in less than 2 months, I have 25 solid years of criminal trial experience. I have never practiced any other type of law. I have been a full-time public defender or a full-time deputy prosecutor my entire legal career. And I also went back to school while still working full-time in Marion County and went to Indiana University and obtained my master's degree in criminal justice and public safety. I did that 10 years after law school, graduated with a 3.8 grade point average. It illustrates my dedication to the criminal justice field. And I've dedicated my entire legal career to the criminal justice field. I believe I'm also the only candidate that has tried murder cases. I've tried several, 2 in this county and more in Marion County. Murder trials are very complex trials. I believe the last murder trial I had, there were 220 pieces of evidence that were admitted in trial. It takes a very skilled and experienced litigator to be able to do that. Doing trials is not something that you can learn overnight. It's a skill that is learned through years of being in the courtroom. And I have always been in the courtroom. That's not something that can be substituted. If unfortunately you had a loved one that was murdered in this county, I would think that you would want the most experienced litigator to prosecute that case. And that would be me.
It's interesting to this whole process has been very interesting to understand the different aspects of law and how each is handled differently. And I don't know, I've learned so much through this. If a law enforcement officer brought forward a case that appeared questionable or involved improper conduct, how would you handle that? And I think this leans toward Henry County being in the news over the last couple of years with the probation department and that sort of thing. So if you had something like that came before you, how would you handle it?
Well, I've actually seen 2 or 3 cases in the last few weeks that we've talked about in my office and wondered why charges were ever filed. I don't want to talk about any pending litigation. I'm not even necessarily saying it's one of our cases in my office, but in reading the police report, we wonder how it ever became criminally charged. Again, I believe what happens in the current prosecutor's office is those police reports, also known as the probable cause affidavit, I believe goes to an investigator who is a retired police officer. And I think he is the one that makes those charging decisions. And it is to be signed off by a prosecutor. I question whether those are actually being read by the deputy prosecutors, because I'm guessing that if many of them were read, some of those charges would not be filed. So I can't say. I don't know if they're just being rubber stamped, or if they're actually being looked at. But we have noticed in my office 2 or 3 cases recently that we're kind of surprised were ever filed. I just don't think they're being reviewed enough by the prosecutors in the office. So
It's
if
never-
I saw a case that came before me and I'm the prosecutor and I read that probable cause affidavit and went, I don't think there's enough here to criminally charge that person, I might have a professional conversation with that officer and explain why I don't think charges should be filed.
Interesting. Interesting. Um, okay, we've heard it said that there's been talk about needing a bigger jail already.
Right.
Most people say that we need swifter justice, not a bigger jail. What types of crimes will you prioritize most aggressively, and what might that look like?
Well, it's kind of a two-part question there. One, I do not believe we need to add on to our jail. I've heard that conversation and I look at the jail list every day. We get it printed out in my office and I look at it every day. The cases are not moving fast enough. One reason, defense attorneys are not getting their discovery, the evidence in the case, swift enough. I have waited 8 months, 10 months, 11 months just to get the body cam footage. I also want to talk about that body cam footage. I think it's on an antiquated system. It takes about 30 minutes to download one video. And I understood from the officers that it takes them about 30 minutes to download it on their part to send it. We've actually had to tie up computers for portions of the entire day trying to download these videos. The other problem is when you look at these videos, you can't back them up. So if you're watching a 45-minute video and something, you go, wait a minute, what exactly was that again? You can't back it up. You have to rewatch the entire 45-minute video.
Oh my God.
The Axiom system is better than what is currently being utilized. It's faster. You can back them up. There's just a lot to getting that discovery and getting it put out faster. I know I keep repeating that, but that is what really, really slows those cases down. How am I supposed to prepare a case for trial or do anything with it when I don't even have the evidence? And it is supposed to be automatically discovered to defense attorneys, and it's not. One of the lawyers in my office is trying to prepare a case for trial, and deputy prosecutor said, now, what exactly do you need from me? And I won't word it quite the way he did. I need every single thing in your file. So it slows the process down. The other problem is these plea agreements. It can take a very long time to get a plea agreement. And unfortunately, when you go to the jail and talk to them about a plea agreement, the first thing they usually say is, that's the first one. It'll get better with time. I'll wait it out. Because unfortunately, that is exactly what happens. If you wait it out, the plea agreements get better with time. That's not the way it should be done. We're going to reverse that philosophy if I'm the prosecutor. I'm going to give you a reasonable plea offer early on in the case, and I'm going to give you a deadline, whether that's 2 pretrial conferences, 60 days. Of course, it's going to depend on the case. For a case such as a murder or something, you wouldn't push it that fast. But for the average typical cases that we typically see, you've got 2 pretrials or 60 days to accept this offer. When you hit that deadline, the offer is going up. I'm adding time to that. That system is implemented in other counties, and I can tell you wholeheartedly it works. Those cases are resolved much faster once the defendants realize that you're truthful in what you're saying. Well, you didn't accept that offer, so guess what? Now it's another year. And you want to take another pretrial? I'm going to keep adding years. Trust me, they get signed. The habitual offender status also is not utilized properly, in my opinion, with the current prosecutor's office. They oftentimes file them on individuals that are eligible. That's a negotiation tactic. If I'm the elected prosecutor, other than certain very extremely heinous crimes, I'm going to use it as a negotiation tactic. You're going to take this plea agreement by a certain amount of time, or I'm adding the habitual. And my policy will be, once I add the habitual, it will never be dismissed. And that is a lot more years in prison, depending on whatever level of felony that you're currently being charged with. I will not dismiss it. If I put it on there, I'm not dismissing it. I'm telling you that that is utilized in other jurisdictions and it works. And it's just not done that way here. A lot of times they file the habitual right off the bat when they first file the charges. You're letting go of a very good negotiation tactic that can move these cases through. And I keep talking about that. Why would we want to move those cases through faster? Well, because all of us that live here in Henry County are footing the bill to house those inmates for $42 per day. That's a typical inmate. Some require more care than that. So if it takes 2 years for somebody to go to trial or decide to take a plea agreement, you paid $42 per day for that inmate. I can give an example. I had a person that in November finally pled guilty to a case that could have been resolved within 60 days, that went to the Department of Corrections for 10 years. We could have resolved that in 60 days. And instead, they sat in the Henry County Jail for 2 years. And we all paid the bill for that. There's just no reason to let them sit and linger in the jail that long. We need to move them on. The other thing is it's good for the defendants also because they get programming, they get more treatment, they can get time cuts. There's more things for them to do once they're sent off to the Department of Corrections, rather than sitting in the Henry County Jail, costing all of us $42 per day. The other thing is, the victims, people that are injured in drunk driving cases or child molest cases or anything, they deserve to be heard. And when I got my master's degree from Indiana University, we talked about how justice needs to be swift. The criminal justice system is designed to be swift, and it's not good when it's not swift. But those victims should be heard early on in that process. They shouldn't have to wait 2 years for their day in court. Actually, I was just talking to somebody today that said their family was getting frustrated going to court hearing after court hearing after court hearing 7 times, and they're never being told by the prosecutor's office what's going on with the case. They take off work, they go to the court hearings, nothing happens. There are things called pretrial conferences, of which we have many in criminal cases, and nothing winds up happening during those. It's basically a chance for the prosecutor's office and the defense attorneys to meet up and decide how they're going to proceed. And that's another thing. I don't think that should actually be done on the court days. That should be done outside of court. The prosecutors and deputy prosecutors should be meeting with defense counsel, not on the court days, but on the days that we're not in court. The court days should be heard for actually having court hearings. Because we often do have victims and family members come to court unnecessarily. And that process needs to happen a lot faster.
Yeah, I like that. I like that a lot. Okay, that's the end of my questions. So if there's anything that you were not able to cover the other night at the forum that you wished you would have had time for, feel free.
I would like to pursue trying to hire a victim's advocate. It was my understanding that Susan Stamper was wonderful. She was our CASA director for a number of years in Henry County. And there came a time when she knew that there was an ability to get a grant to pay for a victim's advocate to work in the prosecutor's office. And she approached the prosecutor's office about that idea, and they just were not interested. Other counties do have, I know Madison County does, or did have one for a very long time, victims advocates assigned. And those are the parties that are going to be trained to meet with the victims. And we talk a lot about victims, and I know there was a lot of talk Thursday night about victims. Of course, as the prosecutor, I have empathy for the victim, but my job is to pursue the perpetrator that committed that crime against them. My job is to go after that perpetrator and make sure they don't do it again. Make sure that they're put away as long as the law allows for whatever crime that they have done to protect the citizens of Henry County. So there needs to be more talked about with, yes, we have empathy for the victims, but we really need to focus on how we're going to take care of it so that it doesn't happen again. And that's where my job comes into play.
Why does it seem like a lot of the sentences for the child molestation cases are minimal? Because, I mean, science has shown that pedophilia is a sexual preference. It's not rehabilitatable. It's not curable.
That is correct. That's correct.
But yet the sentences are mild and they just turn them right back out into society to commit the same crimes again.
Right. Some of that has to do with the sentencing. You know, there's parameters that a person could be sentenced based on the level of felony that it was. And you can't go beyond that. Like a level 5 felony is only 1 to 6 years. They can't get more than 6 years. That's the max. So that's part of it. What I don't like seeing, we had a case recently, not one of mine, where a child was badly injured by mom's boyfriend, and the prosecutor's office gave the defendant a home detention plea offer. Well, guess where that abuse happened? In his home. So what is the point of giving a home detention plea offer when he abused that child in his own home? That doesn't make sense to me. That sentence should only be Department of Corrections, and the prosecutors can ask for that, and the judge can make a determination if anybody knows what an open plea offer is where the judge makes that decision of what that's going to be. And that's where the prosecutor says this should only be an executed sentence in the Department of Corrections. But I certainly would not ever tender a plea agreement to a criminal defendant for home detention who abused a child in his own home. So
that's tragic.
Yeah.
Yeah.
And one thing I noticed a long time ago, I just in society is in general, like you're speaking about, why do these sex offenders have shorter sentences? And again, like the case that was a couple weeks ago, that was a level 5 felony. You can't give them 30 years on a level 5 felony. The max is 6 years. What troubles me though is that a person that sells a little tiny bag of methamphetamine to support their own drug habit, they're consistently wanting 18 years in prison, 12 years in prison for selling a little baggie of meth that weighed a certain amount to get them to a level 2 dealing. But yet I know for a certain instance that a man that had previously been convicted of child molest did a full-fledged child molest and was given a sentence by plea agreement of 11 years. In general, I think it's problematic that we are sentencing drug dealers to longer prison sentences than child molesters. But a lot of that has to do, again, with the legislators and how they have classified these felonies. Level 2 drug dealing is 10 to 30 years. So if it weighs a certain amount, that's a level 2 dealing, it's 10 to 30 years. But a form of a child molest that's only a level 6 or level 5 felonies, 1 to 6 years. So you have to stay within the parameters of the law and the sentencing guidelines.
So if people have a problem with the sentencing, then they need to take it to the state house instead of the county courthouse.
Absolutely.
Okay.
Yes.
Got it. Good deal.
Mm-hmm.
So is there anything else you would like to add?
Well, one thing I would like to see the prosecutor's office and the elected prosecutor, and I would do this. We have, it used to be called JCAP, now it's called JRAP, drug treatment facility within the Henry County Jail that is a very good program. It's a long program. They actually house those individuals in separate units so that they're kind of together. They go to classes. It's a very vigorous, intensive program. And I have really seen lives change going through that program. And they have graduations periodically. We have one coming up. And I try to always go to those. I can't always because of my schedule, but I try to. I've seen Judge Witham there. I've seen Susan Light from probation department there. I've never seen a prosecutor there. And I think it's important for those recovering addicts to be given some credit when they've worked hard in their recovery, to have the people that have been in the Henry County Justice System to acknowledge their hard work. And I would like to see the prosecutor's office represented in those graduations, as well as a wonderful program called Rock and Recovery. It is in September every year. It's been going on for 3 years now. One of our drug court participants created that event. It's an all-day event celebrating the recovery. And I have never seen a prosecutor, anyone from the prosecutor's office at that event. I go every year. I've seen Sheriff Sproles there. I've seen Tammy McKinney from the probation department there. I know that Judge Crane has been there. I would like to see a representative of the prosecutor's office. And I would go to those events. Those
Good.
are citizens of our community. They're going to come back someday, whether they're jailed or go to the Department of Corrections. They're eventually going to come back to our society. We want them to come back as clean, productive members of our society. So I believe in the treatment that they can get, and they should be celebrated when they can overcome that and are no longer actively engaging in the drug-seeking behaviors and using. So
Absolutely. I did not know about those programs. So yeah, very good to know. So
I just think there's needs to be a lot of changes in the Henry County Prosecutor's Office. And me having been on the other side of the fence for 10 years, I know everything that they're not doing correctly and what needs to be changed. And I'm the person to change that. If we don't get somebody new in that office that hasn't been in that office, I think it's just going to stay the same. Nothing's going to change. And I think everybody agrees that there need to be changes.
yeah. Yes, I think that's something that everybody can agree on.
I would agree with you on that one also.
Yes, ma'am. So, okay. Well, I appreciate you rushing back. I know you had to rush back from Michigan
Yes.
and just really taking part in this. This is the first time that I have done this, and I'm hoping that it takes off and that it reaches a much broader audience, because not everybody can show up at the forums or the meet and greets, but
Right.
everybody can click a YouTube link.
Right. And thank you. Thank you for creating this and having us talk and meet the public in this forum.
Sure. Okay. Well, I will send you the link as soon as I get everything loaded up. And with that, I guess we're done. I hope you have a very safe and happy Easter.
You too.
And
Thank you.
good luck at the polls. Thanks,
Thank you.
Cathy.
Appreciate it.